Good morning, dear participants of the annual forum. It's day 2 of our event that we are starting now. Similarly to yesterday, we are going to have 3 sessions today. The first session is going to last until 11:30. Then we'll have several presentations dedicated to the challenges the European Court is facing in interagency cases. We are going to talk about the independence of judiciary, the impact the war has on criminal law, and shaping state policy as to execution of European Court judgments, prospects, achievements, and follow-up steps. So these are the sessions we are going to have until lunch. We'll have a lunch at 12:30. After lunch, we'll have the presentation as to Grand Chamber judgments with respect to Ukraine, and concluding session will start at 2:30. The first speaker today is a big friend of Ukraine, that defended his PhD and doctorate thesis in Ukraine. He is not the first time in this room either, and several of his presentations are quoted by the National School of Judges. They use it or them for different modules at school. I was honored to listen to his presentation on a similar subject matter in summer, and I can tell you from my experience that it's extremely interesting and useful. I'm honored to introduce Judge Latif Husseinov to you, and taking this opportunity, Latif, I would like to say that I remember that you wanted to come to Ukraine in summer, but not in winter. That's the first day of winter, but I do hope that we'll have an opportunity to see you here in summer too. Challenges facing the European Court of Human Rights in interstate cases. Over to you.
Thank you very much. I hope you hear me all. Thank you very much indeed, Madam President, for your kind words. I would like, first of all, to thank the organizers for the invitation they so kindly extended to me. I'm indeed very glad to be with you again. I'm regrettably not able to participate offline, but I want to add that this year I visited your wonderful city twice and gave several lectures. Today, I'm going to speak about the main challenges facing the European Court of Human Rights in interstate cases. I remember some 15, 20 years ago when I was teaching the case law of the European Court of Human Rights at Baku State University. I had very little to say about the interstate complaint mechanism under the convention system. Unfortunately, and I have to put it like this, unfortunately, the situation has subsequently changed, and now this issue has become a rising star in the court's practice. Most of the interstate applications have been launched during the last 15 years, and by and large, they concern armed conflicts. Almost 15% of all pending applications before the court, and the number is about 75,000, relate to interstate conflicts. Of course, there are exceptions. For example, Slovenia against Croatia, Latvia against Denmark, or Liechtenstein against the Czech Republic. These cases, these applications have nothing to do with armed conflict. One of the most serious challenges facing not only our court, but the entire organization is the interstate cases, of course, is the execution of interstate judgments. Specifically those relating to armed conflicts. The reason is clear, is mainly political considerations and extreme sensitivity surrounding these type of cases. The court has very little, if anything, to say about any real success story. And furthermore, compensations awarded by the court in such cases are very high. The first time that the court awarded monetary compensation in an interstate case was Cyprus against Turkey, 90 million euros, and so far, no payment has been made by Turkey. In Georgia, Russia, number one, the court awarded 10 million euros, and so far, no money has been given by Russia. In Georgia, Russia, number two, in April this year, the court awarded about 130 million euros, having previously found several violations committed under the Russian jurisdiction. Incidentally, I think I want to now touch upon one nuance here, a legal point. The wording of Article 41 of the Convention speaks of injured party, just satisfaction to be afforded by the court to injured party. Based on this, there were speculations that no just satisfaction could be awarded in interstate cases. For example, in Cyprus against Turkey, Georgia, Russia, number one, both respondent states, Turkey and Russia respectively, they argued that Article 41 of the Convention was only applicable to individual cases. However, the court held that the overall logic of Article 1 is not substantially different from the logic of reparations in public international law. The court went on to say that Article 41 does apply to interstate cases, as it is the individual and not the state who is directly or indirectly harmed and primarily injured by a violation of one or several convention rights. Therefore, if just satisfaction is afforded in an interstate case, it should always be done for the benefit of individual victims. It follows that if an applicant state submits just satisfaction claims of sufficiently precise and objectively identifiable groups of people, this is the phrase that court uses, individual victims can in principle benefit from interstate cases. I said in principle because there is one important nuance here. It's important for the applicant state to identify the victims in whose favor they are arguing the case and submit requisite evidence that those persons had indeed been suffered from the relevant violations. Otherwise, the court, despite having found violations, will not afford any just satisfaction. For example, in Georgia, Russia, number two, 1,408 alleged victims of practice of torching and looting of houses in the buffer zone had been identified, indicated by Georgia, by the applicant state. The court said that the evidence submitted by the Georgian government had not permitted the court to establish that the houses allegedly poached or looted had belonged to the persons included in that list submitted by the Georgian government, or have constituted their houses or dwellings within the meaning of Article 8 of the Convention. Therefore, the court made no award in this respect. I must add that compensations awarded by the court fail to implement full reparations in the context of armed conflicts. Furthermore, as you know well, monetary compensation is not the only form of responsibility of states under the Convention. To duly execute a judgment, the respondent state must also take appropriate general measures, and individual and general measures. In this regard, it's not clear what kind of general measures must be taken by the respondent state in an interstate case in order to prevent similar violations in the future. Second challenge facing the court: interstate cases, especially in the context of armed conflicts, require the court to examine and assess enormous amounts of evidence, witnesses, and claims concerning a significant number of victims. The court is expected to establish facts that are highly contested. This task is time and resource consuming. For example, Ukraine and Netherlands against Russia. In that case, the court noted that the factual disputes in the case were extensive. Over 1,000 different pieces of evidence had been produced. Many thousands of supporting documentation had been submitted. The court's approach in such cases, as you might know, is free assessment of evidence, including the probative value of the evidence presented. What if the respondent state fails to cooperate? In Georgia, Russia, number one, the court made it clear that a failure on a government's part to submit such information, which is in their hands, without a satisfactory explanation, may not only give rise to the drawing of inferences as to the well-foundedness of the applicant's allegations, but may also reflect negatively on the level of compliance by a respondent state with the obligations under Article 38 of the Convention. In that case, the court referred to the persistent refusal of the Russian government to provide copies of two circulars referred to the expulsion of Georgian nationals. These were documents which the state considered to be essential, which the court considered to be essential for the establishment of the facts. But Russia argued that, according to the national law, they classified as state secrets. And the court reminded that the Russian government could not rely on the domestic law to justify a refusal to comply with the court's request for the production of evidence. And the court found, among others, violation of Article 38, lack of cooperation with the court of the Convention, and put this violation at the very top of the operative part of the judgment. In this regard, I want also to mention Rule 44C of the Rules of Court, which reads as follows: where a party fails to adduce evidence or provide information requested by the court, or to divulge relevant information of its own motion, or otherwise fails to participate effectively in the proceedings, the court may draw such inferences as it deems appropriate. Failure or refusal by a respondent contracting party to participate effectively in the proceedings shall not in itself be a reason for the chamber to discontinue the examination of the application. End of quote. Further interstate cases last for years. Now I will give you some figures. The time needed to adjudicate on interstate cases has continued to increase over the years. The admissibility of the interstate cases lodged in 1950s, 1960s, and 1970s was dealt with in a matter of a few months. The first two cases brought by Cyprus against Turkey, lodged in 1974 and 1975, were adjudicated on the merits by the then European Commission on Human Rights in July 1976. These periods increased considerably in the 1990s and 2000s. Cyprus with Turkey, 19 months. Georgia, Russia, number 1, 2 years and 3 months. Ukraine, Russia, concerning Crimea, lodged in 2014, 6 years. But this is concerning admissibility. As regards the merits, Georgia, Russia, number 1, 7 years. And Ukraine, Russia, concerning Crimea, as my friend Mikola told you yesterday, so soon we will have hearing and deliberations concerning the merits on this case. The just satisfaction judgment required in Georgia, Russia, number 1, required another 5 years. The just satisfaction judgment in Cyprus with Turkey was delivered in 2014, which means that 20 years had elapsed since the last case was first introduced in 1994. The judgment in Georgia, Russia was delivered in 2021, just satisfaction, as I mentioned, 2023, and dealt with the situation that happened in August 2008. Now, two more points. Establishment of jurisdiction, state jurisdiction in interstate cases. I will not dwell on this issue because my colleague Ivana Jelic yesterday, she touched upon this issue, and I think she highlighted the controversial points concerning jurisdiction, specifically following the judgment Russia against Turkey number 2. And the last challenge, I think, what proves to be difficult in interstate cases, and not only in interstate cases, but also in individual cases relating to armed conflict, is to establish by the court which set of rules, humanitarian law or human rights law, is to be applied in specific cases. Again, that was, in fact, the topic of the presentation of my distinguished colleague, Ivana Jelic, yesterday. Just one point, probably, I will wish to add here. Judge Jelic rightly spoke about the co-applicability of the international humanitarian law and human rights law during armed conflicts. In principle, this is true. Probably, I would need to add one point, which might be here my subjective view, probably even maybe not shared by my colleagues, but I think that's something that I would like to draw to bring to your attention. If you have a case, if you have a situation that, let's say, falls under the convention, and normally you have to apply the relevant convention provision, but during armed conflict, there is a dilemma because you have applicable rules of international humanitarian law. And the court, in such a case, has to choose. So the strict term of co-applicability, in my view, doesn't apply here. Because you cannot apply simultaneously two rules that contradict each other. So you have to attach anyway priority or decisive importance to one of them. Either it's the convention or it is humanitarian law. Because you have to tell the applicant, you have to tell the parties whether or not there was a violation. If you apply the convention, probably there will be a violation. For example, in Hassan case against United Kingdom or Hanan against Germany. If you apply the humanitarian law, then the court will not find a violation, as it was in these two cases. So I think here it's a matter of principle. Again, as I said, two conflicting rules, co-applicability can hardly exist by definition, because you have to apply one of them, as I said, because they conflict each other. And it's not easy. Of course, we can talk about kind of convergence or trying to interpret so that this conflict is not so obvious. But this is, again, as I said, a matter of principle. But in a specific situation, when, for example, we have to answer a question whether the investigation conducted by the authorities was effective or not under Article 2 of the Convention. As you know, we have very strict rules of the Convention concerning the effectiveness, very strict criteria, effectiveness of the investigation under Article 2 or 3. So if, for example, in Hanan against Germany, the court had applied the Convention and the court's case law, it must have found a violation of Article 2. But we know that it didn't find, because it applied humanitarian law. So therefore, you see, here, it's not the co-applicability, but it's finding an answer to the specific question under the Convention, or not under conventional, but under, let's say, under applicable rules, given the realities of armed conflict, given the realities of armed hostilities. I think here, what the court's case law shows that so far, as we can see from these two cases, so far, in the context of armed conflict, the court seems to attach decisive importance to international humanitarian law. Thank you very much for your attention.
Дуже дякуємо, суддя Хусейнов, за ваш такий ґрунтовний виступ.
Thank you indeed, Justice, for your very important presentations, for referrals to speeches of our colleagues. I think that Judge Knutowski yesterday stated that the state in the interstate cases represents rather the people than the state as such. So you indeed referred very relevantly to the tools in the possession of the state, but this is up to the state to decide to which extent it represents its population. And yes, yesterday's speech by Justice Yevich about correlation between the international humanitarian law and human rights law. Thank you indeed for your speech. Do the audience have any questions, please? Yes, Judge Savchak, talking about international humanitarian law. If you think about the cases where the international humanitarian law would prevail in all cases of this kind.
If there is a collision, of course, I think if, for example, we are talking about something that's that's regulated in an identical manner by the two set of rules, I think this issue doesn't arise that you mentioned. If there's a contradiction, for example, I mentioned the one issue relating to effectiveness, where you have this collision between the two rules, two sets of rules, or in Hassan case where the issue was whether internment of civilians during armed conflict, which is allowed under humanitarian law, which is not unlawful deprivation of liberty under humanitarian law, but which is certainly violation of Article 5 normally, because Article 5 does not provide for this exception among the 6 exceptions that are strictly foreseen in that article. And then the court faced this dilemma. So, internment of civilians without proper procedures, and this ground in itself is unlawful under Article 5, then the court must have found violation of Article 5, but it said no violation, because it referred to international maritime law, to the Geneva Convention, number 4. So here, as I said, when there is a contradiction between the two sets of rules, then, as our case law shows, the courts will attach priority to the international maritime law. So thank you again for your question.
Дуже дякуємо і за запитання, і за відповідь.
Thanks a lot for the question and for the answer. If there are any other questions, please feel free to do that. Okay. I don't think that's going to be abuse of your procedural rights and my rights of moderator. What do you think? The principle of adversariality, how important it is for the court. So, adversariality, so if this court could take initiative, maybe that's an interstate case, maybe other cases.
This is now the second time that I'm facing a situation where I don't understand one word. Because of that, you know, my Ukrainian is a bit limited. I used to speak well, but I forgot. Can you please, the word that I didn't understand?
Adversariality, adversarial. So we are talking about adversariality principle. So each side, each party provides its own arguments. And if the court says that some arguments were not provided and they are apparent, would the court take that into consideration?
Adversarial proceedings, equality of arms, or in English? I have to, because I don't understand this word.
Exactly. That's what.
Adversarial procedure, yes. Article 6.
Yeah, Article 6.
So, and thank you very much. So the question is whether you said that during these adversarial proceedings, one of the parties does not provide sufficient evidence or sufficient testimony, or could you please repeat the question, because I think I should understand in order to answer. Probably I should listen to translation, interpretation. Yes. Could you please, moderator, help me?
Actually, the question was whether in wartime, in marital times, adversarial procedure should be applied ordinary and the peaceful time, or slightly different, given the armed conflict into intention.
Okay, now I understand. Yeah, thank you. Yes, then it's a good question. So that means, let's say, procedural safeguards under Article 6, procedural safeguards under Article 6, whether they can be fully applied by the court, or let's say whether the court will take into account the realities of armed conflict. I think if that's the question, then I think we can easily answer to this question, referring to the example that I mentioned, effectiveness of investigation. So you have certain criteria developed by the court as regards effectiveness of investigation, and there the court did not apply strictly these criteria and said clearly that during armed conflict you cannot provide, for example, full independence or impartiality of the investigation at stake. So it's adversarial, as regards adversariality, in a specific case, I don't see, frankly speaking, I don't see circumstances where the court probably would differentiate whether it's peacetime or whether it's wartime. There might be certain issues regarding the procedural safeguards, how to ensure them during armed conflict, as regards, for example, publicity, as regards presence of persons. But I think, fundamentally, in any case, the court will have a look both in peacetime and in wartime at the, in my view, decisive criterion, which is entire fairness of proceedings. Entire fairness of proceedings. And I don't exclude that in examining the entire fairness of proceedings, in examining these aspects, the court might take into consideration the realities of armed conflicts. But again, we have never had such a case regarding Article 6 in the context of armed conflict. But that is that's my general view how the court's approach would be in such a case. But I think that was a very interesting question.
Дуже дякуємо, суддя Хусейнов.
Thank you very much, Judge Hussein, and looking forward to seeing you in Ukraine, either in this room or elsewhere. Thanks a lot for your presentation. I think the question raised with respect to adversariality principle and its application is part, as it was said, of the overall guarantees of the court, and national judges face this when considering any cases, including criminal cases at wartime. So one of the issues or one of the challenges that crop up since the beginning of the full-scale invasion, whether the judge could stay impartial and independent when administering justice, whether the judges can adjudicate war crimes cases with the same guarantees of impartiality and objectiveness, and whether martial law does have an impact on fairness of the court and the guarantees Ukraine should abide by under the convention. The issue of independence of judiciary is the subject matter of the next presentation, and I'm happy to give the floor to our next speaker, the judge of the European Court of Human Rights, Armen Arutyunan. Armen, over to you.
So are you hearing me? Is it okay? Because I have
Так,
some
ми вас
problems.
чуємо, бачимо.
Okay, thank you.
Yes, you can.
And I am very grateful for this invitation, because everything which connected to Ukraine is very close to my heart as a former member of Human Rights Monitoring Commission during the First War. And on purpose, I suggested this topic, the independence of judiciary in member states and the role of European Court of Human Rights, because just previously my colleague Latif was speaking about interstate cases, and if you go deeper into all these conflicts, you will see that these conflicts rooted in stemmed from departing of one or both sides of the conflict from democracy and the rule of law. And independence of judiciary, from my point of view, as both local production, is a good indication which kind of regime we are dealing with. Unfortunately, now European Court of Human Rights, European Convention, human rights in general is facing huge challenges, and it is not secreted by some member states as well, and that is why judiciary is an important one. So of course European Court of Human Rights functioning based on several principles and conditions. One of the important principles is a principle of subsidiarity, which means that primary role for protection and supporting of human rights also depend and belongs to national institutions. And the European Court of Human Rights just is providing European control. And the other condition that before be able to bring application before our court, it is necessary to exhaust domestic remedies. But all this makes sense if we are dealing with country, with member state where there are effective remedies. So national institutions are in line with Article 13. And that is why at court several times sent messages in regard to fair trial, independence of judiciary as well, that democracy is the only regime in which it is possible to have effective remedies. So and another way how court is trying to facilitate role of national institutions to be in line with convention, we have landmark cases where court is providing test roadmaps for national institutions to facilitate their role, their functioning, their understanding, how they have to deal in order to be in line with our case law, with convention, and to deal and to be as a one big network based on the same system of values. I will present you topics, and based on these topics, the landmark our cases and messages which court is sending to member states. And after that, if you have questions, with pleasure, I will be at your disposal to respond. So, independence of judiciary and democracy. In regard of this, the court has always emphasized the prominent place held in democratic society by the right to a fair trial. Stanev versus Bulgaria, Grand Chamber 2012. The guarantee is one of the fundamental principles of any democratic society within the meaning of the convention. Mamaladze versus Georgia, 2022. The judges offers a legal protection in disputes between citizens and the government and between citizens themselves, thereby helping to ensure fair and just societies and limiting abuse by governments and state authorities. The right to fair hearing must be interpreted in the light of the preamble to the convention, which declares, among other things, the rule of law to be part of the common heritage of the contracting states. Arbitrariness entails a negation of the rule of law and democracy and cannot be tolerated in respect of procedural rights and more than in respect of substantive rights. This is a message in regard to democracy and independence of judiciary. Links with a democratic society. The judiciary's fundamental role in a democracy is to guarantee the very existence of the rule of law and thus to ensure the proper applications of the law in an impartial, just, fair, and efficient manner. As you see, court using methodology from the wider notion to the narrow. So we will come step by step into the cases. In regard of the procedure and fair trials, in regard of fairness, court has established several tests which comes from different cases. Fairness includes the following implied requirements in criminal and civil cases: adversarial proceedings, Roe and Davy versus United Kingdom, equality of arms, Bratseter versus Austria, presence and publicity, Ripon versus Austria. Fairness furthermore includes additional implied requirements in criminal matters. Entrapment defense, Ramanauskas versus Lithuania. Right to silence and not to incriminate oneself, Sanders versus United Kingdom. And right not to be expelled or extradited to a country where one may face a flagrant denial of a fair trial, Mamaktulov and Askarov versus Turkey. As we see from the methodology and special cases and special principles. So in courts, the other topic and message which courts sent to member states is that courts must inspire confidence in a democratic society, because courts are not only providing justice in the society, but and social balance, which is very important. In order to determine whether a tribunal can be considered to be independent and required by Article 6, paragraph 1, appearances may also be important. And in Stramek versus Austria, court sent a very clear message that the confidence within the court must inspire in a democratic society. And this is another function which must be provided by courts. Particular facets of democracy and the functioning of the judiciary. Sanctions against judges, including removal. In regard of this, court has as well, via its case law, very clear messages. Judges cannot be excluded from the protection of Article 6 on the ground of their status alone. Moreover, judicial independence should be understood in an inclusive manner and apply not only to a judge in his or her adjudicating role, but also to other official functions that a judge may be called upon to perform that are closely connected with the judicial system. In Grzyta versus Poland in 2022, court found that the exclusion of access to a court for a judge who was a member of the National Council of the Judiciary, which had constitutional responsibility for safeguarding judicial independence, and who had been prematurely removed from his post following a legislative reform, in the absence of any judicial oversight of the legality of that measure, had not been justified on objective ground in the state's interest. Furthermore, in Emenajoglu versus Turkey in 2021, in this case, when the applicant was a judicial officer of the first grade, he was transferred to a post in Chankiri by the second chamber of the High Council of Judges and Prosecutors, by way of disciplinary sanction on account of his statements and criticism, particularly about high-profile cases in the media. The court considered it was difficult to say that the proceedings before this council complied with the requirements of the procedural safeguards under Article 6. They were in fact mainly in written proceedings and afforded very few safeguards to the judge prosecutor concerned. And in this connection, the relevant legislation didn't contain any specific rules on the procedure to be followed on the safeguards allowed to judges and prosecutors before this council, or on the manner in which evidence was to be admitted and assessed. There are several messages in regard to institutional requirements. We know that the institutional requirements, we have three requirements for institution. It is that tribunal established by law, independent tribunal, it does have an institutional and personal right, and impartial tribunal, where we have subjective and objective parts. So, and in Grand Chamber in Gudmundur and Assarsson versus Iceland in 2020, court refined these relevant case law principles, such as independence, in particular of the executive, impartiality, and duration of its members' term in office. And a very good example of bodies that have been recognized by the court as having the status of a tribunal within the meaning of Article 6, paragraph 1 can be seen in Hogja versus Albania in 2021, which related to bodies set up on an exceptional and transitional basis to re-evaluate the ability of the country's judges and prosecutors to perform their functions in an effort to combat corruption. The other message messages which our court is sending is appearance of independence and impartiality. And even appearance may be important. What is at stake is the confidence which the courts in a democratic society must inspire in the public and above all, as far as criminal proceedings are concerned, in the accused. For instance, where a tribunal's members include persons who are in a subordinate position in terms of their duties and the organization of their service vis-a-vis one of the parties, accused persons may entertain a legitimate doubt about those persons' independence. And therefore, in Saynar versus Turkey in 2001, the court considered that the applicant tried in a martial law court on charge of attempting to undermine the constitutional order of the state could have legitimate reason to fear being tried by a bench which included 2 military judges and an army officer acting under the authority of the martial law commander. The fact that the 2 civilian judges whose independence and impartiality are not in doubt said in that court made no difference in this respect. Internal organization and existence of national procedures and safeguards. In order that the courts may inspire confidence in the public account must also be taken of questions of internal organization. In Persak versus Belgium and in Meržanic versus Croatia in 2005, court made very clear message that the existence of national procedures for ensuring impartiality, namely rules regulating the withdrawal of judges, is a relevant factor when taking into account questions of internal organization. Such rules manifest the national legislature concern to remove all reasonable doubts as to the impartiality of the judge or court concerned and constitute an attempt to ensure impartiality by eliminating the causes of such concern. Dear colleagues, yet in 1984, in the case Campbell and Fell versus United Kingdom, court sent a very clear message and test in regard of we are calling it independent test developed by court. This test regarding the independence of tribunals consists of 4 elements. First, the manner of appointment of its members, the duration of their term of office, the existence of guarantees against outside pressure, and whether the body presents an appearance of independence. And this test was thereafter reiterated by the court several times, for instance, in Maktub and Damjanovic versus Bosnia and Herzegovina in 2013, and more recently in Ramos Nunes de Carvalho versus Portugal in 2018. And this test, beginning from 1984, hasn't been changed. I want to say that messages of our court are very clear and maps which we are sending in regard of different parts of this issue are very clear as well. And by all means, court tries to facilitate the role and the function of national institutions. You know very well that in some countries there is some like high judicial councils which are in charge of to remove, to dismiss, or to impose disciplinary sanctions over judges. And in regard of this, court sent clear message as well as a test in Alexander Volkov versus Ukraine. I will not go deeper into the test, which after reiterating Denisov versus Ukrainian Grand Chamber. And of course, we all know about a very famous case, Baca versus Hungary, where court as well underlined the problem with access to the court. So, and finally, I have to say that it is very important, and court is underlining that very important for member states to provide access to court, finality of court decision, res judicata, and timely execution of final judgments. So at this point, I will stop, and I'm at your disposal if you have questions. So this is a role of European Court of Human Rights to design and to send roadmaps, tests, and methodologically and value of systems, that democracy, rule of law, and different tests in regard to different parts of independence of judiciary. Thank you very much.
Дуже дякуємо, суддя Рутюнян.
Thank you very much, Judge Rutunian. Democracy, human rights, independence of the judges, and the way the tests recommended by the court are applied. Questions? Serhiy. Good morning. Thanks a lot for your presentation. As of today, given the war ongoing in Ukraine, the society faces an issue of dealing with war crimes and crimes committed by servicemen. Despite established case law of European Court of Human Rights to this end, anyways, the issue of establishing military courts, given the fact that in Ukraine we do have a military prosecutor's office, is being raised in terms of necessity among the lawmakers. Do you believe that it is possible, when we have active stage of hostilities during the armed conflict and during some time after the conflict is over, do you believe that it is possible to establish this type of courts that would have exclusive competence only with respect to servicemen?
May I repeat the question in order to be sure that I understood correctly, that so that taking into account the current situation of the invasion in Ukraine, so whether it will be in line with our convention to establish special courts. Am I right or no?
Special military courts dealing with
martial military court in regard of military issues, yes, in regard to the soldiers, not for citizens, not for civilians.
Not for civilians, for military servicemen.
In some cases, and I remember that maybe several cases versus Turkey as well, so court is recognizing these courts, but not for civilians. This is the issue. And when we have to take into account that this is not absolute right, and sometimes taking the special particular situation, member states can deviate from some rights, and taking it into account this, if it is military martial law for military servicemen, yes, just I gave you that it should be adversarial, so equality of arms, so this person has to be provided right to defense his rights as well. But if everything in line with this, so why not? The problem is that sometimes these military martial courts are dealing with civilians. Here is a situation problem, but with the military service, yes, the convention and court, at least I don't know that there is a case where we are against to such type of courts.
Дякую, Сергій Анатолійович, якщо ви задоволені. Наскільки я зрозуміла, ваше питання стосовно...
Your question was twofold. It was not only about establishing specialized military courts, but also the possibility of establishing these courts during the martial law. Am I right? So these were two things there. Or there was something else?
Якщо можна, якщо у вас є ще щось додати.
If you would like to add anything, dear judge, then please.
So this is question to me. I don't understand, because maybe I need some translation to understand.
Ну, якщо ви вже відповіли, то дуже дякую. Якщо є
If
ще
you answered the question, then thanks a lot. But if you want to add something or clarify your answer, then please, you can do that.
не було перекладу. Мені підказують учасники, що можливо.
Participants say partial interpretation was absent, so not the full question was translated.
Відповідь зрозуміла. Дякую.
We understand your answer. Thank you. Do we have any further questions to Judge Harutyunyan? Yes, good morning. I'm Irina Kushner from Council of Europe. Thank you for joining us. In Ukraine, we have quite a hot question of vetting judges with regard to their integrity and honest behavior. But I would not think about the judges, but rather I would think about whether the public is allowed to conduct such vettings, because, you know, we have this Public Council for Integrity, which actually is in charge for selection, evaluation of judges, and respectively. The question is whether it is possible that this public councils of integrity were making, delivering their opinion on the integrity of potential judge, would in the meantime look into any judgments delivered by this judge and their opinion with regard to these judges' judgments should be part of their opinion. So I see here kind of a contradiction. We have this Public Council for Integrity with their proper functions and competences, but on the other hand, if they check the judges delivered by the judge, again, to assess his or her integrity, is that reasonable? So maybe you can think about any case law of European Court which would cover this potential possibility for the public or journalists to evaluate judges.
Body in Ukraine, which is examining whether judges will be able to provide and to continue their functions. And this body consists by journalists and different members of society. Am I right or not?
Так, ви праві. Вона називається Громадська рада доброчесності.
Yes, you're right. That's Public Council for Integrity.
I will not talk about exactly this case and the situation in Ukraine, because I'm not sure that tomorrow we will not have, so maybe we will have case in front of our court. That's why I don't want to express exactly about this body. But the vetting system in Albania, we know, and for all these bodies, because the autonomous interpretation of the court in regard of tribunal established by law, it doesn't mean that it should be only courts. It could be in another bodies. But that's why I mentioned Alexander Volkov versus Ukraine and Campbell and Fell versus United Kingdom. In Volkov versus Ukraine, court designed all that requirements which must be in line with the given body. In order, we consider this body as a tribunal established by law. And of course, in regard of independency of members and institution and impartiality. If this body in line and is compatible with all these requirements, so court doesn't have problem with these type of bodies, because I mentioned in the Albanian case then where we're dealing with vetting process, not classical courts, but court recognized that body as a tribunal established by law. That's why these two cases are very important for you, this Fell and Campbell versus UK, and particularly Alexander Volkov versus Ukraine, which after reiterated by Denisov versus Ukraine. And here, where all tests are here, and this body must be in line with these requirements. In that time, it will be recognized as a tribunal established by law, and of course, all tests in regard of independence and impartiality of members. If it is not, it is not. That's why the messages and roadmap and tests are very clear, which we are sending to member states. And if there is a will, there is a deal. I want to say that if there is a wish to be in line with convention, our case law is very clear in regard to this. So I have no idea on which basis this body was established, was formed, but these cases, here you can find answers to your question. Thank you.
Дякуємо дуже. Чи є ще запитання?
Thank you. Do we have any further questions? Cannot see any raised hands. Thank you indeed, Justice Harutyunyan, for joining our forum, and we certainly hope we'll see you soon in Ukraine, not online, but offline, live. The next topic, according to our agenda, is devoted to development of criminal law and impact of the war. Over such development, do we have Svetlana Hiluk online? Yes. Svetlana, good morning. It's a pity you are not with us in this room. So please, the floor is yours. Well, thank you. Thank you indeed, colleagues, for this opportunity to communicate with you today, to share some of my thoughts. Indeed, I'm not happy because of my absence in your room, but I had to take a trip to Kyiv, so now I'm somewhere in the midway between Kyiv and Lviv. I apologize for technicalities. Do I have any chance to share my screen to make my presentation? Yes, you can. Great. Just a second. War, criminal law, and human rights. Just another moment, sorry. Some technical points, I apologize. So, today I'd like to share with you some thoughts which unfortunately are relevant for Ukraine with regard to war, criminal law, and human rights. So today we'll speak very briefly about three things. First, where the human rights are still relevant for wartime. We'll mention some legal standards of European Court on the wartime. Why do we have this first question, whether the human rights have effect under the war? These doubts were generated by judgment of European Court in famous interstate case Georgia versus Russia. And although the intensive phase of aggression of Russian Federation against Georgia lasted for just few days, still when the European Court received this case for consideration, they stated, well, there was a question of extraterritorial jurisdiction, and we know that any state exercises its jurisdiction within its territory, but in some situations, a state can be responsible for violation of human rights committed beyond its territory in case if such state had effective control over the territory or over a specific person. So in case of aggression of Russian Federation against Georgia, the question was about who had this effective control over the territory occupied by Russia during the intensive phase of the warfare. So, in their judgment, the European Court took a standing or held that it was not possible to establish in that case who had this effective control, which certainly generated logic question whether human rights have effect during the war, because an acute or intensive phase of any conflict, the basic rights provided by the convention are violated. So this position of European Court that during the intensive phase of a conflict it's not possible to establish who had effective control. In fact, that meant that at such times the human rights regime is not effective anymore and becomes illusionary. Of course, for Ukraine, such standing had significant risks because if it's not possible to establish who had effective control during Russian Georgian war, so what could we say about shelling and bombarding of Mariupol and other the population centers? I'm sorry, I have to interfere here. But Lviv, we have the air raid alert, and all of us have to go down to the shelter, and we need to take care of our security. We shouldn't stay in this room because of that. So let's make our decision. What do we do? I had to. Yes, I had to ask this question. The point is that we have to follow the rules of international organization. It's a bit more difficult, complicated than asking the parties, so we are forced to take a break. My question to Svetlana, what about our schedule? Because we have no idea when the alert will be cancelled. So that will just continue moving towards Kiev, and when the air raid alert is over, is cancelled, then we'll look for the solution because it can last for 30 minutes or it can last for 3 hours. We never know in advance, if that's a big for Russian Federation that can take quite a long time. So maybe if it's convenient, I would maybe get in touch by the end of your panel because by the time I'm supposed to be in Kyiv, and it will be more convenient for me. Yes, we'll see the way we will have to move forward. Indeed, we need to go down to the shelter. Those who are with us, yes, we have the shelter in the basement, and you're even free to leave the university building, which is beyond our control, so we urge you to stay in shelter. For those who are online, now we are forced to interrupt our online broadcast, but as soon as the alert is cancelled, at least in Lviv, we will get back. So please follow our notifications and join us after the
Для двох перерв, однієї вимушеної, другої скороченої обідньої. Трошки відбулися у нас зміни за програмою. Я переконана, що на якість виступів це жодним чином не вплине. Тематика, яка пропонується зараз, пов'язана з деякими проблемами перегляду Великою Палатою Верховного суду судових рішень у зв'язку із встановленням Європейським судом з прав людини порушення Україною конвенційних зобов'язань. І я передаю слово одному з ініціаторів і натхненників ідеї проведення цього форуму, а в теперішній якості судді Великої Палати Верховного суду Дмитро Гудимі.
Добрий день, шановні учасники. Я щиро дякую організаторам за те, що багато років підтримують цю ініціативу, за те, що колись визнали, що Захід заслуговує на увагу після перших двох вдалих форумів. Дякую за таке представлення. Ну, якщо ліричний такий невеличкий відступ, то справді ідея проведення Міжнародного форуму з практики Європейського суду з прав людини, вона зародилася випадково у 2012 році з, фактично, за столом, так би мовити, і віртуально 3 людей. От одним з яких справді був я, другим був Петро Мойсейович Рабінович, професор і мій науковий керівник, і третім мій однокурсник, власне, який працював в Європейському суді з прав людини. І виникла така думка, що можемо через такі заходи більше знайомити людей, які зацікавлені в проблематиці між собою, знайомити їх з Європейським судом з прав людини, його суддями, їхніми поглядами, їхнім баченням судової практики. Так це все з'явилося. І на 3-й форум, на 3-й рік підтримав координатор проєктів ОБСЄ в Україні цей захід. І отак цей захід живе до сьогоднішнього дня, за що я ще раз кажу, дуже вдячний і сподіваюся, що певні якісь позитивні результати він дає навіть на 11-й рік свого існування. Те, про що я хочу сьогодні поговорити, мабуть, дещо з цього я вже вчора згадав, і ми зараз до цього теж повернемося. Кілька таких вступних зауваг. По-перше, щоб повернути всіх до, так би мовити, того, що в нас є, та що ж таки, дуже чутливий, вибачте, клікер. Мушу до нього звикнути. Хочу нагадати всім деякі там положення закону, не буду переказувати з приводу виконання рішень і застосування практики Європейського суду з прав людини, але на що важливо звернути увагу. Дуже часто заявники, які приходили до Великої Палати Верховного суду, вони мали хибне враження про те, що кожне рішення Європейського суду з прав людини, яке вони отримують на свою користь, дозволяє їм претендувати на перегляд рішень національних судів. І часом навіть були такі достатньо комічні ситуації, особливо в 2018 році, коли заявники у справі Бурмич та інші проти України вирішили, що це рішення їм дозволяє переглядати рішення національних судів, ухвалені на їхню користь. І Велика Палата була, скажімо так, навіть, можна сказати, перевантажена зверненнями щодо перегляду рішень, ухвалених національними судами на користь заявників. Ця проблема іноді і далі виринає, коли певні рішення Європейського суду з прав людини, в яких встановлено порушення Україною міжнародних зобов'язань, заявники хибно сприймають як таке, яке дозволяє переглядати за виключними обставинами рішення національних судів. Важливо, що закон, він фактично нам натякає на те, що перегляд він можливий тільки тоді, якщо справді завдяки перегляду рішень національних судів ми можемо відновити настільки, наскільки це можливо, попередній юридичний стан нашого заявника. Фактично, так, вибачте, не знаю, хто це гортав. Фактично тільки в законі, чи то безпосередньо із закону, і випливає те, що не у всіх випадках можна переглянути рішення національних судів. Отже, не можна навіть відкривати провадження, на моє переконання, за кожною із таких заяв. І тут, звісно, певно, проблема є у процесуальному законодавстві. Якщо приклади якісь того законодавства є на екрані, ну ж з Цивільного процесуального кодексу України, якісь цитати, то це тільки ілюстрація. Ілюстрація, вона абсолютно одинаково, норма звучить і в інших процесуальних законах. І виходячи з приписів всіх процесуальних законів, сказати, що заявники можуть завжди претендувати на перегляд рішення, теж не можна. Проте, на жаль, так законодавець сформулював приписи, що у багатьох, в тому числі і суддів, не тільки заявників, складається враження, що потрібно в переважній більшості випадків, скажімо так, якщо заява оформлена відповідно до вимог процесуального закону і стосується перегляду рішень національних судів на підставі рішення Європейського суду з прав людини, де встановлено порушення Україною міжнародних зобов'язань при вирішенні справи судом, що треба відкривати провадження за такими заявами. Велика Палата Верховного суду вже в 2018 році фактично сформулювала певні, ну, можна назвати це фільтрами, можна назвати, знову ж, таким тлумаченням, яке дозволяє краще розуміти випадки, за яких перегляд рішень національних судів є можливим. Я тут хочу привернути вашу увагу також і до ще одного моменту важливого. Це присічний 10-річний строк, який встановлений у всіх процесуальних законах, на подання заяви про перегляд рішень національних судів. Цей 10-річний строк, він створює низку проблем, і про ці проблеми я згадав вчора, а нині про них скажу детальніше. Крім того, знову ж, зверніть увагу, що ця проблема, власне, 10-річного строку, вона, ну, я б сказав, так би мовити, неодноразово виринає в практиці Європейського суду з прав людини, коли він ухвалює рішення і встановлює порушення Україною міжнародних зобов'язань вже тоді, коли 10 років після набрання чинності останнім рішенням, ухваленим не на користь заявника на національному рівні, Європейський суд фактично після спливу цих 10 років ухвалює рішення на користь заявника. Як ви бачите, вперше ми зіткнулися з цим питанням у 2018 році в березні, коли заявник звернувся про перегляд рішень судів у справі, де брала участь авіакомпанія ЗАД АТІ проти України, і фактично було відмовлено у відкритті провадження, керуючись тим, що строк присічний. Іншої думки на той час не виникало, чи можемо у Великій Палаті Верховного суду інакше подивитися на такий 10-річний строк. Надалі, після відкриття провадження ще в одній такій справі, де 10-річний строк сплинув, справа стосувалася виконання рішення Євросуду в справі Котенко та інші проти України, Велика Палата Верховного суду знову ж вирішила, що не можна в такому провадженні переглядати судові рішення, і те, що одноособово суддя відкрив провадження за відповідною заявою, вона колективно відповідне провадження за виключними обставинами закрила. І от дійшла справа у 2021 році до Великої Палати, де стояла мова про перегляд рішень національних судів після рішення ЄСПЛ в справі Горяйнова проти України. На цій справі я окремо зупинюся, але зверніть увагу на особливості, червоним позначено, так, виділив спеціально, на особливості цієї справи. Рішення Євросуд ухвалив 8 жовтня 2020 року. Дві ухвали Вищого адміністративного суду в тій справі були. Одна з них датована 27 квітня 2010 року. Тут ми зразу бачимо, що 10-річний строк сплив вже на момент звернення до Європейського суду, на момент ухвалення Європейським судом з прав людини рішення. І друга ухвала про відмову в допуску справи до перегляду у Верховному суді України 31 грудня 2010 року. Можна було би в цій справі вирішувати питання про те, чи можемо ми вважати, що 10-річний строк не сплинув, тому що є друга ухвала, про перегляд якої теж просила заявниця, яка датована 31 грудня 2010 року. Проте Велика Палата дещо інакше взагалі подивилася на цю ситуацію. Звернула увагу, що заявниця, незважаючи на те, що 10-річний строк з часу, коли Національний суд ухвалив своє останнє рішення в її справі, хоч він і сплинув, але ця заявниця і далі зазнає порушення її конвенційних прав, і те відшкодування, яке їй запропоноване, воно, на жаль, її права не відновлює. А мова йшла, це справа про звільнення з органів прокуратури, де заявницю звільнили без дотримання гарантій, які надає Конвенція про захист прав людини і основоположних свобод. І оце ж вона з 2010 року, чи то, власне, останнє рішення 2010 року, так, до 2020 року, чи до кінця 2020 року, судилася в Європейському суді з прав людини з державою. Я звертаю увагу на цю справу саме тому, що саме в ній вперше Велика Палата вийшла за межі того 10-річного строку, сказала, так, він пресічний, але є досвід інших країн, які у виняткових ситуаціях дозволяють переглядати рішення національних судів після рішення Євросуду, дозволяють переглядати такі рішення національних судів, навіть коли цей 10-річний строк чи пресічний строк, відведений національним законом, він сплив. Керуються тим, що якщо заявник і далі зазнає негативних наслідків рішень національних судів, ці наслідки мають бути усунуті шляхом перегляду судових рішень. Це була, так би мовити, пілотна справа у Великій Палаті, де це питання було вирішене таким чином, але ми мали і подальше продовження. Не знаю, чому не перегортається слайд. Продовження, як ви бачите, було в справі Жвавий проти України. Теж, так би мовити, випадає із загального переліку. Справа стосується захисту свободи вираження поглядів. Україна, на щастя, порівняно небагато має програних справ за статтею 10, але здебільшого ті, в яких Європейський суд ухвалив рішення на користь заявників, вони демонструють реальні проблеми із вираженням поглядів і демонструють, скажімо так, реальні проблеми, в тому числі і в сприйнятті цієї свободи в нашому суспільстві. І от в цій справі одна з проблем полягала в тому, що заявник, незважаючи на те, що отримав рішення Європейського суду з прав людини знову ж більш ніж через 10 років після ухвалення останнього рішення на національному рівні, бачите, різниця була невеличка, 1 місяць, навіть менше 1 місяця розділяло заявника, так би мовити, відділило його від жорстких умов, які встановлює процесуальний закон. Оцей заявник, він, як ми побачили з матеріалів справи, він і далі зазнавав негативних наслідків рішень національних судів. Чому? Тому що ті рішення, які набрали законної сили, вони і далі перебували в процесі виконання, зокрема в частині, яка стосувалася стягнення з нього коштів на користь іншого учасника спірних відносин. І, по-друге, в виконавчому провадженні також був накладений арешт на якесь майно цього заявника. І фактично це говорило про те, що наслідки рішень національних судів, вони створюють ефект навіть після спливу 10 років, і навряд чи можна іншим чином відновити становище цього заявника. Крім того, і це дуже показово, на рідкість, саме в цій справі Європейський суд з прав людини прямо вказав, що перегляд рішень національних судів чи відновлення провадження в справі на національному рівні, воно би було бажаним для відновлення становища заявника. Це дуже нечастий випадок, коли таке пише Євросуд. І от, беручи до уваги в сукупності те, що Євросуд сам сказав, що відновлення провадження у справі, це, так би мовити, найкращий шлях для реституцію ін інтегрум, беручи до уваги те, що заявник і далі, виходячи з його пояснень, зазнає негативних наслідків рішень, ухвалених на національному рівні, це в сукупності дозволило Великій Палаті Верховного суду переглянути судові рішення, про перегляд яких йшла мова в заяві, були скасовані рішення всіх 3 інстанцій судів, і справа відправлена на новий розгляд до суду першої інстанції. Ці 2 справи Горяйнової і Жвавого, вони напевно, не напевно, а точно це єдині 2, в яких Велика Палата Верховного суду пояснила, чому вона не може сприйняти імперативний припис процесуального закону про те, що не можна переглянути рішення національних судів, коли сплив 10-річний строк. Більше того, зауважу, що зараз на розгляді у Великій Палаті Верховного суду знаходиться цікава справа, пов'язана з виконанням рішення в справі Удовиченко проти України. Знову ж питання 10 статті Конвенції. Цікавий дуже зріз, можете почитати, власне, саме рішення Євросуду, щоб побачити проблематику. Але дивіться, зверніть увагу на що. В цій справі на національному рівні було 2 ухвали, 2 остаточні рішення, 2 ухвали Вищого спеціалізованого суду з розгляду цивільних і кримінальних справ. Одна була 18 грудня 2013 року за касаційною скаргою нашої заявниці Удовиченко, 18 грудня. А друга за рік до того, 14 березня 2012 року, за касаційною скаргою відповідача. І цікаве питання, власне, виникає, який тут, от, власне, з якого моменту тут відлічувати цей 10-річний строк. Рішення Євросуду датоване 23 березня 2023 року. Чи можна сказати, що тут не сплинув 10-річний строк, бо за її касаційною скаргою цієї Удовиченко ухвала була 18 грудня 2013 року, чи все-таки остаточним рішення стало тоді, коли вже було переглянуто судове рішення апеляційного суду за касаційною скаргою відповідача? 2 ухвали ВССУ, хоч між ними є рік перерви, вони за змістом практично одинакові. Одна є дзеркалом іншої ухвали. Як тут бути в такій ситуації? Чи можна сказати, що 10-річний строк пропущений? Це питання. Це одна з проблем, яка залишається. Справа перебуває на розгляді. В ній декілька в цій справі проблем. Одна з них – це ця. Якщо, читаючи рішення Євросуду, це не очевидно, то я спеціально до цього привертаю увагу і ілюструю. Власне, про аргументи в систематизованому вигляді, аргументи Великої Палати щодо рішення Євросуду в справі Горяйнової, ви можете зараз ще раз побачити на екрані. Ключове – це те, що держава повинна виконати рішення, і якщо ми бачимо, що заявник зазнає і далі негативних наслідків рішення, яке ухвалено на національному рівні, то повинні бути вжиті відповідні заходи для того, щоб відновити становище цього заявника, навіть якщо 10-річний строк сплинув. На відміну від справи Жвавої проти України, в цій Європейський суд не казав, що відновлення провадження на національному рівні, воно є бажаним для відновлення становища. Не казав. Но тим не менше, якраз ці 2 випадки, вони достатньо яскраві, і в сукупності з усіма іншими це десь, по-перше, демонструє проблему, яку ми маємо із строками розгляду справ проти України в Європейському суді з прав людини. Довго, так? Що минає строк на звернення із відповідною заявою про перегляд рішень національних судів, той строк, який визначений національним законом. І друге, це ілюструє, зрештою, і недосконалість процесуального механізму. Зрозуміло, що на шальках терезів стоїть, з одного боку, необхідність забезпечити сталість судового рішення. Рішення вже може бути виконане і повороту не можна допускати. З іншого боку, стоїть на шальках терезів інтерес цього заявника, і якщо видно, що його можна відновити, тут людина з роботи так була звільнена, як вказав Європейський суд з прав людини, що це суперечило конвенційним гарантіям таке звільнення з роботи в органі державної влади. То якщо можливо відновити становище такого заявника, то іншого варіанту, ніж допустити перегляд таких рішень навіть за межами 10-річного строку, мабуть, немає. Важливо врахувати, що в цих всіх ситуаціях заявники не винуваті, що Європейський суд з прав людини ухвалив рішення пізніше, ніж наш передбачений процесуальним законом строк. Тобто ніхто ж на це не має впливу, коли він розгляне справу і ухвалить рішення. Оце прошу, так би мовити, взяти до уваги, і якщо будуть надалі виникати подібні ситуації, то має бути розуміння того, в яких випадках Верховний суд вважає, що можливо, чи то навіть, вибачте, необхідно застосовувати цей 10-річний строк, а в яких в порядку винятку і для якої мети потрібно виходити з інтересів заявника. Ще один момент, власне, скажу щодо справедливої сатисфакції. Зверніть увагу ще на одну проблему, яка не часто трапляється, але останнім часом з'явилася в практиці Європейського суду з прав людини. Проблема зі справедливою сатисфакцією, яку він присуджує, і що створює для національного суду певну дилему, проблему, яку треба вирішувати, щоб для себе зрозуміти, чи тягне таке рішення Європейського суду з прав людини необхідність перегляду справи на національному рівні. Норма конвенції ніби все зрозуміло. Статті 41, що за певних умов Європейський суд може присудити справедливу сатисфакцію. Так, цих умов є декілька, все ніби ясно. І він це зрештою робить. Але подивіться, що відбулося в цій справі Удовиченко проти України, про яку я згадував і стосовно якої, власне, зараз перебуває справа на розгляді в Великій Палаті. Гляньте, яка цікава річ. Заявниця вимагала присудити їй в Європейському суді з прав людини
reimbursement of moral damage and pecuniary damage. So 10,000 euro for pecuniary damage and 50,000 moral damage. Everything seems to be simple and clear, but let's have a look. My clicker is very sensitive, unfortunately. So let's have a look at the results. Okay, so they awarded a general amount, 14,300 euro, for all of the points of the claim. Now, let me explain you something, where the problem was. The national courts, they collected some money from the applicant, and the amount that they collected was less than the ECtHR awarded. Now, this 14,300, what it consists of, because she was claiming that it's 50,000 to compensate for moral damage. Apologies, that's not me. Well, she requested 50,000 euro to compensate for moral damage. Now, from that amount awarded by the ECtHR, 14,300, maybe, 14,200 would be for moral damages. But then the pecuniary damage was not fully covered. Maybe it was covered in full. Nobody knows. The problem is whether the applicant still suffers from the bad decision of the court made at the national level. So it's not just about collection of some money from her, but also it was about the need to refute the false information. Speaking about refuting false information, two parties saw this differently. The applicant said that she completely fulfilled that judgment with regard to refuting false information by using a certain media outlet, but the other party says it's not true. Now, what actually happened? Has this information been refuted in the media? Based on the information from the case file, we just cannot tell. Speaking about financial part, we do have this problem. So can we believe with this kind of approach from the ECtHR when they award the general amount without a breakdown, saying that this is for pecuniary damage, this is for moral damage, then maybe in this case we say that this applicant is no longer suffering from bad decisions, from bad court judgments, because this award from the ECtHR fully covers the amount that was collected from her based on the decision of the national courts. So that's a good question and a complicated question because it impacts the end result. So there could be several approaches. If we are looking at the amounts only, there is no problem. She was fully compensated. But it was a dispute between two private participants. No one paid anything into the budget. And then the other party in this civil case received the money directly from the applicant. And from the state budget, then, in pursuance of the judgment of the ECtHR, something was paid to benefit this applicant. Can we consider this as full coverage of the cost that she incurred while enforcing the court judgment? And in this case, she has no right to revise that decision of the national court. No one asked that kind of question before, but revising that decision, stopping enforcement when the national courts and their judgments are cancelled, and then we have to start the process anew. And then that means that on one hand, she is getting money from the state budget in pursuance of the ECtHR judgment, and then on the other hand, she is getting money back at the national level, the money that she had to pay in the beginning to the other party. So the defense says, well, it just cannot happen. Look at the overall amount. All these legal constructs, they do not apply in this case. If the total amount fully covers the amount awarded by the ECtHR, then we say there are no negative consequences for this applicant. We understand this approach, but this still creates a problem. It's a special problem, very specific problem, which we never seen before. And to finalize, I want to once again mention the most complicated episode. That was just a warm-up, intellectual warm-up. Now this is not going to be supported by detailed comments. This is just an explanation. This is what's happening. In all criminal proceedings, where we talk about some serious violations, the right to fair trial, for example, the ECtHR in this case, very often evaluates whether the proceedings at the national level were just and fair overall, and whether those actions of the state did not undermine the fairness of trial, the proceedings or the trial in this case. Now let's have a look at the problem that popped up recently. It's based on the language, on the terminology and linguistics, probably. So it's 2010, Borotyuk versus Ukraine. Everything seems to be clear and straightforward. There is a violation, and the European Court says undermining the overall fairness of trial. So that means that it was not fair. So let's revise, if possible. Let's revise the case. Now we continue this situation. I hoped there would be no problem, but we do have a problem with the clicker. Now, 2016, the fairness of proceeding was not undermined. Very well, we cannot say that it was not clear. Let's move on. Okay, not me. That's the clicker. But okay, let's have a look at this case. Same year, 2016. The formula is quite interesting. Was not irretrievably prejudiced by the restriction of the applicant's access to legal advice and failed to demonstrate convincingly. That's where we have an issue. In the same case, we have some general conclusions that allow us to understand that those violations actually took place. The government failed to prove, failed to demonstrate convincingly why exceptionally and in the specific circumstances of the case, the overall fairness of the trial was not irretrievably prejudiced. Well, it's not a perfect construct from my standpoint. But again, let's have a look at something recent. Back in 2019, we have the similar language saying that undermine the overall fairness of trial. Everything is kind of clear, but then 2020 comes. The plot gets thicker. The government have not shown that the authorities displayed appropriate diligence, and then in this case, just a second, in Chernica versus Ukraine, where they talk about overall fairness of criminal proceedings. Well, the problem pops up again because the ECtHR says that the above-mentioned combination of circumstances was capable of prejudicing. So who is supposed to evaluate? Was it capable or was it not capable? So there is no imperative wording in this case. From a standpoint of enforcement of the judgment, with this kind of wording, we have a discussion now. Whether the ECtHR was able to find that it was undermined, the fairness, or was capable of undermining, but it didn't undermine. So, is it mandating the Supreme Court to keep a close eye on this wording or not? And then maybe altogether they will have to look at other evidence and see what actually happened. Because let's say the majority says this wording does not allow us to claim that it was undermined, the fairness of the trial. So they voted. The Committee of Ministers in the Council of Europe says, no, you are not enforcing the judgment. We meant that it was capable of, and capable of means actually undermined. So why then you say capable of? Why can't you say undermine? Because that creates ambiguity in interpretation. Back in 2010, that was not the case. Now, let's have a look at 2021. A new plot. The ECtHR says that to undermine the overall fairness of the criminal proceedings against the applicant, taken in combination, they had such an effect. So separately, individually, no effect. In combination, they had an effect. Well, they could have used the same language from 2010, saying that undermined the overall fairness of trial. Why they changed the language, I have no idea. Now, there is another interesting language from 2022. That's the most complicated one. The most complicated from everything we have seen for the last 5 to 6 years in relation to Ukraine. So Suslov and Vatican versus Ukraine. Now, in this case, the Grand Chamber just adopted a decision. A few days ago, we don't have the full text of that decision, but this is what we have. You know, this new formula did have an impact on the overall fairness of the trial. You know, the restriction in question did have an impact. Then, in the same judgment, we have another point, another paragraph. Impact on the overall fairness of the proceedings was, however, limited. So it was, but limited. So if it's limited, are we supposed to revise the case at the national level in courts or not? So it didn't really undermine anything, right? It was limited. There was some kind of impact. There were some sort of restrictions to the rights of the applicants. So there was some kind of impact on the overall fairness, but that's not it. Same judgment, the ECtHR says that there were other deficiencies that have some impact on the overall fairness of trial. And at the end, it's not working again. And at the end, they say there is yet another violation mentioned by the applicant, which could undermine the overall fairness of trial. So very complicated for understanding, very unorthodox presentation of ideas compared to what the words they used to use before, like in 2010. And for the Grand Chamber to operate, you know, because they're responsible for enforcing these judgments, that creates a problem, right? If each and everyone will read up on this judgment for Suslov and Vatican case, it's a big judgment. If you read the details, you will understand what I mean. Why all these paragraphs, which I have seen on the screen, why they create such a problem, and why they are very controversial. I cannot claim that this is just a suggestion. Any kind of text which we draft or anybody else drafts, it will be imperfect every time, because different people have different perception of what's written. But nevertheless, if the ECtHR has introduced certain language, certain formulas, then digression from these formulas will impact the national enforcement practice, right, of the ECtHR judgments. So let's just stick to this one type of wording. Let's not deviate when we create such serious conclusions, such serious judgments. This is when my presentation is over, and I'm grateful for your future questions. And in the process of discussion, I will be able to also listen to your comments about the case law of the Grand Chamber of the Supreme Court. You can talk about issues that you've noticed when they enforce ECtHR judgments. Thank you so much. Thank you for this intellectual warm-up. Thank you for this undermining effect. So you have provided us a lot of interesting things to think of. Any questions? My name is Narizhny Alexander. I'm from the Commercial Court in Dnipropetrovsk Oblast. Very interesting presentation. Thank you so much. Very interesting stance on this matter. But when you spoke about the stance of the Grand Chamber, I had a question. And the National Court already tried to answer this question. So we talk about this 10-year deadline for revising a court judgment based on new circumstances because of the court judgment was repealed, and that has become the foundation for a new judgment, which is now being revised because of new circumstances. So the national courts, can they use this view of the Grand Chamber similarly to the revision of judgments when new circumstances arise? Yes, honestly, I believe that no. Why? Because these two cases, Goryainova and Zvave, and the justification I spoke of, and things you've seen in a concentrated fashion, the arguments of the Grand Chamber, why we look at this case outside the 10-year term limit, that's an exception. On one hand, on the other hand, it's a special procedure, which is connected to the implementation of Ukraine's commitments on the international treaties, and it's about Convention on Fundamental Freedoms. And to implement it, enforce it, we adopted a law to enforce the case law of the ECtHR using all the mechanisms in our procedural legislation so that we could revise the judgments of domestic courts. But this has not been done with the purpose of comparing this procedure of enforcing of ECtHR judgments with the procedure of revision of domestic court judgments because of new circumstances. Well, these two procedures, they are jammed within one section. They are regulated by the same articles, but as for me, these opinions mentioned in the special procedure for enforcing ECtHR judgment with regard to individual measures, well, these opinions, these conclusions, they do not apply in cases where there are new circumstances. We probably would not have this question if the legislature would draw a line between the two procedures clearly. And it makes perfect sense. You know, I spoke about this yesterday, and I can remind you why. It's important. They have this problem of 30-day deadline to review the case based on the ECtHR judgment. It's just not possible. You know, why we mandate a judge from the Grand Chamber to unanimously open proceedings when this case is properly filed and documented. Then they have to wait for the authentic translation from the Ministry of Justice after 30 days, because that case needs to be brought back from the archives and sent to the Grand Chamber. In many cases, there is no more case. I'm not talking about situations where we have cases sitting in the occupied territories. There are proceedings still in place, so 30-day period is nonsense. You know, maybe there was some good idea about making it happen, but technically it's not possible. And had the legislature separated this procedure from the procedure of revision of cases under the new circumstances, well, maybe then we would say, okay, for this case we have this deadline. When we talk about the enforcement of ECtHR judgments, we have a different deadline. And in this case, I'm answering your question, which is quite obvious. The different norm of a procedural law in this case is applied, and the interpretation is different. It's not that obvious today, but from my clear belief, I said at the very beginning, in Horyainova and Žvavy case, it's very special. We cannot use the opinion of the Grand Chamber in this case to interpret the norms with regard to revision of domestic court judgments under new circumstances. Okay, I understand. Thank you. Mikhailo? Yes, I have a question. Lately, we keep getting judgments from the Supreme Court where you talk about violation of deadlines for consideration of cases and also the violation of deadlines for detention. We understand that these cases are still being tried by the appropriate courts. So you found this violation. So then we have the ECtHR judgment, which are being now looked at by the first instance courts. So now the question is whether the court is supposed to say that there is a violation independently, or how those kind of judgments are supposed to be considered in ongoing trials. Well, okay. I cannot really provide you with a recipe how to present your opinion in a court judgment at the first instance court, or maybe you have to state something like that. Let's look at this problem from a different perspective. If the ECtHR already found a violation of the reasonable terms for trial, why do you have to repeat the same language in your domestic court judgment? The ECtHR found a violation during a certain stage. Let's say it's first instance court. This still enables the claimant to appeal again and again because this case, conditionally speaking, may be tried for another 5 years. He will apply again. He will complain again, saying that first instance court is still looking at this case. Then they go to the Court of Appeals, and then nothing happens there. They complain again. So see, the claimants are not restricted in terms of the number of complaints for violations of deadlines for hearing the case. So in this kind of situations, to avoid enforcement of judgments, ECtHR judgments, in some legal systems, they introduced this approach where the government is paying fine for violating the deadline. So it's an administrative procedure. So this claimant may just go to the government and, they will have the overdue judgment, because they have a certain deadline to hear the case and they violate the deadline, and then the government will pay the fine, the compensation to this claimant. So had the government been paying these compensations, then the ECtHR would not award those compensations. See, at the national level, we just don't have that kind of mechanism, and all these claimants, they are getting some money from the state, from the government, for violation of the reasonable deadlines, and then they get this money as a result of the ECtHR judgment. So had the state introduced the mechanism of compensations at the national level with certain criteria, had they found an agency who could evaluate the deadlines and look at in every case and decide on the amount that is payable to this claimant, so had the government have done it, then those claimants would not be able even to go to the ECtHR because the government has this mechanism. That mechanism needs to be exhausted first, right? And then the amounts that are introduced at the national level, they don't necessarily have to be exactly the same, which will be then collected through the ECtHR judgments. The amount could be less. When the government is doing something on its own, proactively, when they allow for this kind of payouts, they can make sure that the payment is less than the payment awarded by the international court. So then the government will have to pay more because now the government violates international treaties, international commitments. So then the state is supposed to be interested in doing this. And some people spoke about introducing a mechanism, but we don't have it so far. But again, coming back to your initial question, I believe that all these things about violation of reasonable deadlines, they cannot really be reflected in the judgments of the first instance or cassation courts. Okay, thank you. Final question. I will try. a similar question. We have so many judgments where they state the fact of prolonged detention. So in this case, the criminal proceeding is still ongoing and you still keep the individual in custody. So when a judgment is made, the defense will request to release the person because there is the judgment from the ECtHR. Now the prosecutor immediately responds differently. They say not enough by itself. That's the language they use. That's not enough. And there are many more reasons why not to release such a person from detention. So what do you think? If the ECtHR says there is a violation, can by itself it become the grounds for release? And then they apply some interim measures, but not detention. And then we can try and complete the criminal proceeding. Thank you, Anna, for your question. We cannot have one cookie-cutter response to this. We don't have one single recipe because of many reasons. The applicant, at the moment of sending the complaint to the ECtHR, that applicant was deprived of freedom based on subparagraph C, paragraph 5 of the convention. But then when the ECtHR judgment became final, that applicant has been deprived of liberty based on subparagraph A, paragraph 1, article 5. He has been convicted by the court in this case. Happens every time. And then there are other configurations that exist. In the case of this applicant, while his case was in the ECtHR, new judgments were made by the national court, and these judgments were not evaluated by the ECtHR. They did not see any arguments from the domestic court, and it's visible from their text. Now, how can you in this situation say that the evaluation of previous judgments is directly connected to the new judgments? Maybe sometimes we could do this, but hypothetically, all those judgments are carbon copied. Okay, so same exact arguments, just you revise the case every few months. The result is the same. The motive is the same. This is more interesting, right? This is where you have to sit down and think. But when we talk about the situations where the court, during the time of consideration in the ECtHR, adopted new judgments to hold the person in custody with different motivation. Something was used to support the initial judgments, then that became no longer relevant, new decisions were made. So how do you establish this correlation between the ECtHR judgment from the past and extension of detention today in the light of the right to liberty? So I do not see any correlation in this case. There is one problem, though, which is quite interesting. If the trial continues, proceedings continue, the situation of the applicant did not change. He is in custody based on the same exact subparagraph, paragraph 1, article 5 of the convention. So he remains in custody, and all the judgments have been carbon copied without any additions or... Right, this is a very interesting situation. And it's widespread. Right, this situation is widespread. And very few people know what to do in this kind of case. And I don't have a recipe for you. And I am not ready to tell you now what can be done. We never looked into this case. The Grand Chamber received applications from people deprived of liberty in violation of convention. They would apply to us so that we would repeal the judgment for holding them in custody or extension of custody. We had cases like this, but the Grand Chamber cannot revise those kind of judgments. Then they go to you, and they ask this question to you. Now, what do we do? I don't think we can give them a universal answer in this kind of case. You just have to think. Right, the questions and answers now show us how these problems are important and pertinent. Okay, let's move on. Dmitro, Thank you so much. Thank you for your responses, dear colleagues. Thank you for your questions. And to continue the moderation process, Irina Kushnir will now take over. And she is from the Line Project for the Judiciary from the Council of Europe. Right, thank you. And now, because we don't have time, I'm giving the floor to the following speaker, which is going to be a logical continuation of the previous presentation, my Dmitro Gudema, because the following session, the following speaker will talk about enforcement of ECtHR judgments. So now, Alisa Petukhova will speak online, and she is from the ECtHR, from the Secretariat, and she will talk about state government policy with regard to enforcement of the ECtHR judgments, challenges and problems. Hello, good afternoon. I hope you can hear me. Yes, we can. Right, thank you so much. Thank you for allowing me to present. I'm very happy to welcome everyone. The previous speakers raised very important topics. And I myself wanted to intervene at some point, but we don't have much time, of course, and we have to investigate so much to be able to find answers for previous questions which were raised by Mr. Gudema. I don't want to take too much time. I want to immediately jump to my presentation. So allow me to start my screen sharing. I hope you can see. Yes, we can continue. Well, my topic is about development of government policy and enforcement of ECtHR judgments, achievements and existing issues. I want to emphasize the impact of ECtHR judgments on implementation of the government policy in Ukraine. Of course, we know that enforcement of ECtHR judgments is not simple. We have the commitment to enforce these judgments. This commitment has arisen a long time ago. And as mentioned by Mr. Glutovsky yesterday, we do have some outstanding systemic problems which are not connected to the war. Unfortunately, the war also changed things. And now we have these systemic problems, and their addressing is not easy because of the war, among many other things. Now, the topic of my presentation is about the enforcement of ECtHR judgments, and this whole session is about this important topic. So allow me to begin by saying that Ukraine has ratified the Convention on Protection of Human Rights, and based on Article 46 of the Convention, the ECtHR judgments are mandatory and binding. Now, we have also line legislation, the law on enforcement of case law and judgments of the ECtHR, and Article 2 of this law is talking about the fact that all government agencies of Ukraine shall enforce the appropriate judgments. And they talk about the need to implement the convention and the case law of the ECtHR as the source of law. So the convention has become a part of our national legislation, and it shall be enforced by all government agencies, not just by the Supreme Court, not just by the Ministry of Justice, but by all government agencies and local government included, because in the understanding of the case law of the European Union, they are members of the government. So this allows the citizens, after they exhaust all national mechanisms and safeguards, they can go to the ECtHR as an international final instance, allowing to seek protection of human rights. Unfortunately, today, Ukraine has become a leader from other countries with regard to the number of complaints sent to the ECtHR, and you can see the number of those complaints. So Ukraine goes first, then Russia, then Turkey. So Ukraine is one of the countries where we have the largest number of decisions which have not been enforced. But in this case, we do have some good progress. Now, as of today, 762 unenforced judgments, 102 leading cases, the cases which we look at and guided by when we enforce other judgments and when we shape the government policy, when we change it in the purpose of enforcement of ECtHR judgments and to comply with the European standards and the standards of the Council of Europe. Also, I wanted to say that all government agencies must protect the rights of people and respect their rights. Still, the government agencies have this idea that the Minister of Justice and the Commissioner are the two officials responsible for enforcing the judgments. Now, the ECtHR Commissioner is a public official from the Ministry of Justice. He's been appointed by this cabinet, and that's the official responsible for coordination of enforcement. That person does not have powers to make somebody enforce the judgments. Well, that's a very important position because the commissioner will receive the initial complaints from the applicants and the initial judgments from the ECtHR, which the ECtHR sends to Ukraine for enforcement. I must mention that it's important to raise the understanding that it's important to stick to the rights and guarantees, and then the just and fair satisfaction will be awarded, because otherwise things create a huge load on the state budget. Had the government agencies received the information beforehand, we could have fixed the situation, but this does not happen too often. The law contains some general provisions with regard to implementation of ECtHR judgments, but these judgments are very different, and the approach to enforcement also has to be on a case-by-case basis, like Mr. Gudimo just said. When we talk about excessive detention, and each and every judgment needs to be looked at individually. There are pilot judgments, quasi-pilot judgments. And oftentimes they would come up with a very short judgment and a quick reference to the previous case law. And they then talk about the fair satisfaction, which has been awarded in this or that case. And one government agency cannot really fix this problem. As I mentioned before, enforcement of judgments is the responsibility of the state, and the public is paying for this through taxes.
Заходів для пришвидшення реформування системи виконання рішень судів, зокрема і рішень Європейського суду з прав людини. Хочу звернути увагу присутніх на проблеми, з якими стикаємося загалом під час виконання рішень Європейського суду. Це, от як вже було сказано, надмірна тривалість проваджень у цивільних та кримінальних справах, це неналежні матеріально-побутові умови тримання під вартою осіб, відсутність медичної допомоги в установах тримання під вартою виконання покарань, відсутність передбаченого законодавством ефективного засобу юридичного захисту за такими скаргами. Також це недоліки законодавства, пов'язані з тим, що покарання у виді довічного позбавлення волі не підлягає скороченню. Це група справ Петухов номер 2 проти України, вчора про неї згадували на форумі. Також це недоліки законодавства і практики, які призводять до тривалого, незаконного та необґрунтованого тримання особи під вартою без належної законної підстави, про що також щойно йшла мова. І інші теж порушення, не буду на них зараз акцентувати увагу, хочу перейти до найважливішого, на що хотіла сьогодні звернути увагу під час свого виступу, це саме рішення пілотні та квазіпілотні, які мають значний вплив на формування державної політики в Україні. Запровадження процедури ухвалення пілотного рішення було зумовлено Європейським судом у зв'язку з тим, що до нього надходила велика кількість однотипних скарг на порушення прав, гарантованих конвенцією та ухваленням рішень. Суть пілотного рішення – це
the substance matter of the pilot's decisions provides the possibility for adequate compensation at the national level. On one hand, this has to reduce the flow of cases if the national authorities were not. On the other hand, the legal remedies would find it easier to consider those cases if the national authority has already considered the cases. Burmach and Ivanov cases were also mentioned yesterday. I would like to speak about this in more detail. This envisages judicial control over the implementation of court decisions, and up until now, there is still a situation without the possible assessment of their implementation and the legislation that cannot be implemented. This is about numerous social benefits and that have become a big burden for the national budget. The first pilot decision versus Ukraine was the decision of Yuri Ivanov versus Ukraine on lengthy non-implementation of decisions of national court. This was adopted because such complaints were more frequent, and then the Committee of Ministers has recognized the structural issues with the implementation of decisions of the National Court. In this sense, the European Court has called upon Ukraine to introduce legal remedies. However, despite the fact that various measures were taken, they did not lead to proper solution. And the ECtHR has basically become the fourth instance court with very typical cases, with a big load of typical cases versus Ukraine, while adopting the decisions based on Article 37 of the Convention, while establishing this
швидкого отримання компенсації, можливо, з виконанням рішення, можливо, навіть і досі без виконання рішення.
Without implementation,
не зміг виконувати належну свою функцію за статтею 19 Конвенції.
They could not do this under Article 28 of the Convention. As a result, the European Court has adopted a different approach in Burmach versus Ukraine. And with reference to Article 37 of the Convention, they removed more than 12,000 cases and said that all of these statements have to be transferred to the Committee of Ministers of the Council of Europe, and together with the government of Ukraine, they have to resolve these problems. Further adoption of these decisions is under strong control, and at least once a year, the government of Ukraine is reporting about implementation of measures, and it also provides information about resolving the individual cases, individual decisions.
Так і з міжнародними організаціями, зокрема і якраз з Радою Європи та Prava Justice.
With private justice system, this implementation is also being done. There's also these measures are still insufficient, and the Committee of Ministers emphasizes the need to strengthen the political will to adopt additional measures and for general system solution. Thanks to the Cabinet of Ministers and according to the ECtHR practices, in 2020, the government of Ukraine has adopted a national strategy of problem solving towards implementation of court decisions, which outline the key problems and strategic approaches of its implementation. Why is this important? Because Before that, the government of Ukraine has never provided its vision of the reasons behind this problem. And with this strategy, the government has actually recognized that the problem is there and it is related to multiple factors.
Пов'язані з збором інформації, фінансова, звісно, причина та відсутність засобів юридичного захисту. Також було розроблено план заходів для реалізації цієї стратегії. Водночас цей план заходів
At the same time, this plan of measures is more directed at the problem solving, and the methods of this problem solving is examined the experience of other countries of the Council of Europe, and that helped.
Виконання рішення судів, проте це не вирішило проблему як таку.
This did not resolve the problem as such. The war made us review the approaches because of the war. The plan of measures until 2025 was adopted with the help of the Ombudsman, together with the civil authorities, with the public authorities. It contains ambitious measures, but since it was adopted by the government of Ukraine, it led to the fact that the state recognizes
реалізації цієї політики, і, зокрема, в таких аспектах. Перше, це розроблення механізму обліку і верифікації рішень суду.
This devises the decisions and the amount of debt and its settlement and compensation, because at the moment the state does not have information neither about the number of cases adopted against the state and state institutions or the amount of debt, which is only growing every day, because unfortunately certain categories of people which require assistance from state budget are only growing, but the legislation does not always envisage the funding of these initiatives. And in order to look into these problems with the previous debts and the current debt, and we may have that, and first we need to look at the decisions we need to take.
Ця робота буде надскладна, проте вона вже потрошки розпочинається з державними органами і міжнародними організаціями. І ми
This is considered by the international organizations, and in the beginning of 2024, we will start working.
Це, так би мовити, дерадянізація соціального законодавства України.
And this is the deregulated national legislation of Ukraine, because we need to change the policy and social platform in the state. Currently, the legislation is stipulating a lot of social payments which are not being implemented, and that only causes further problems to the state. The assistance has to be targeted for persons who are in difficult life circumstances, regardless of the category that the person falls into. This is just part of the work, and besides that, they are also focusing on these issues, and this was demanded by the European Union, and it was demanded in the assessment of Ukraine for the EU. And Sukachov versus Ukraine case is related to improper conditions of imprisonment. I will not elaborate on that. And it affected Ukraine's possibility to resolve these problems. And despite the fact that there's this complex preventive measure of this to the solution, we would like to emphasize that the state policy in the area of implementation of punishments is implemented by the European Union in the case. On the 16th of December 2022, the strategy of reform of penitentiary system was established until 2026, and the operational plan until 2024. One of them is the review of the conditions of imprisonment. The operational plan envisages clear tasks for the improvement of custody. At the same time, the available funding sources are insufficient for the implementation, and we will further work with state authorities to work on this problem, to resolve this problem. And unfortunately, you only have 5 minutes left. Okay, then I will try to focus on the decision related to Lithuania versus Ukraine. It's a very famous decision, disciplinary responsibility of judges. There were a number of violations in this decision, and there were cases in general. There was independence and impartiality of the justice of the parliament while they were reviewing the case of disciplinary responsibility of the judge, lack of appropriateness and lack of bias at the state of court review, general legal uncertainty, and the state authorities have done a lot to fix that. From 2014 to 2020, legislation was approved, amendments were made to legislation, High Council of Justice was established. And there were multiple reforms. The reforms were positively assessed by the Council of Europe with a warning that still they are waiting for information regarding the work of the service of disciplinary inspectors of the High Council of Justice and the responsibility, criminal responsibility of the judges. I don't want to leave the decision in Gumenyuk versus Ukraine without decision. It's super complex, but at the same time, it is related to former judges of the Supreme Court of Ukraine, and we have not only the decisions of the European Court, but also the decisions of the Constitutional Court of Ukraine, which established that the liquidation of the Supreme Court of Ukraine is not under legal grounds, and the judges could not be dismissed like that, despite the decisions of the ECtHR on the Ukrainian policy. The law was adopted to resolve the problem. We will be looking forward to a positive solution of the cabinet ministers on this situation. ECtHR versus Ukraine is another pilot decision reference to Article 46 of the Convention. The court emphasized the need to review national practices on the preventive measures of custody, and this is exactly what was mentioned by Mr. Hudima. The problem really is very serious, and we can see its solution in the need to improve administrative practices, the need to adhere to the conditions of the Convention on custody conditions. And since we already have some positive changes in the legislation, that's already a good thing. Virinsko versus Ukraine decision of 2014, which was related to the problems of peaceful gathering, seems to be, to me, Ukraine is just the country that could not simply make a decision on that, but the Committee of Ministers has proven on multiple occasions that despite the fact that we do not have a legislation about peaceful gatherings are still being conducted. We had Maidan, we had peaceful gatherings on specific categories of groups of population. We have the Dialogue Coalition, which we can already see near Chesklavra. During peaceful gatherings that are ongoing even in the times of war. I would also like to focus on, well, I have a sort of selection of decisions. Karnaka versus Ukraine 2013. 2013 was related to intervention in the private life of the person because our legislation did not envisage the possibility to change the patronym for a person. Amendments were made, and respectively, this decision is implemented. And that also relates to the fact that the decisions of the ECtHR are actually shaping the state policy. I see you, Marina, last decision that I'd like to cover. Maimulakin and Marco versus Ukraine is a fresh decision, 2023. A very interesting decision, violation of Article 14, prohibition of discrimination, related to Article 8 because of the lack of mechanism of legal recognition of single-gender couples. The ECtHR mentioned violation of prevention. Short-term is international legislation. Ukraine already has a draft law registered in the Parliament of Ukraine, which is directed at the solution of this problem. Generally, this problem is not a new thing for the European Union, but this is the new decision for the ECtHR versus Ukraine. And it is further complicated by a lack of understanding of the state authorities, plus it will be additional burden on the implementation of these decisions in the civil society. There's no study will make a lot of pressure. And as we're adopting respective legislation, we will try to prove this to the Committee of Ministers, and the European Union is also interested in this. And this is the attempt to become part of the European family. And there are lots of cases like that. We just need a forum to sort of prove what kind of practice, what kind of influence the ECtHR practices have on the practices of Ukraine. I would like to tell more and perhaps discuss more whether or not the ECtHR case law is important and whether or not we need to expand the understanding of the civil authorities and the understanding of this, how to lead these decisions for their implementation. Thank you, Irina. Thank you. Any questions from for Elisa? Dmitra, please. Thank you for this presentation. I am curious. Well, we've been talking about this for 2 days now, about the organization of the reporting of all cases, the state and their implementation.
В цій стратегії передбачено це розробка механізму обліку і верифікації рішень.
The verification of court decisions. I have a question. Why are we approaching to develop a new system of verification and accounting for court decisions? Why can't we envisage a mechanism under which the courts are adopting decisions and are with an option of, I think, versus the state, as it can the same registry or a different registry wherever the information goes. With this way, we could take into account all the new decisions. This problem has existed for multiple years. These decisions would already be accounted for, and of the old period over the past 10 or 15 years, somebody would be amending that, for example, through the decisions of the ministry. Is there a need to create new mechanisms for the decisions that are made versus the state? What does this mechanism do for the new court decisions? Why do the courts and their authorities and the court administration through the court registry, why can't they do this accounting with the current situation? Thank you. The current decisions envisage the possibility to account them and with the calculation according to the debtor. If the debtor is the state institution or organization, that should be taken into account from the beginning of the work of the system. Unfortunately, the system still does not work fully because of the shortage of funding. So we are in constant contact with the judicial administration as to the problems of the non-implementation of decisions, the needs to calculate the decisions of the court versus the state as to the debtors, as to the property situations, the amounts. It's all available for the future, but it's not yet implemented. Every day when the decisions are made, they will be referred to the previous ones because there's a big backlog of cases that are still not calculated. There's a mechanism on the old decisions. So the future decisions, they will have to be calculated by a city system. Okay, just one clarification. If you could please explain why the state registry in present form cannot be used for this accounting and verification. What prevents them from working? Maybe it needs to be improved. Maybe there's a need to see how ECtHR would be working, etc. State court administration informed us that it cannot be improved to calculate these decisions at the moment. Perhaps its software does not envisage such functions. And we see this in any cases working already. It is not working fully. Only certain components are being connected, and we're just looking forward to have this component switched on completely. Thank you. A very brief comment because we need to move on. By way of previous question, is it possible to establish a normal a special registry for the ECtHR decisions?
Реєстр рішень Європейського суду.
The registry of the ECtHR decisions?
В Європейського суду є свій реєстр, так би
The
мовити, це
ECtHR has its
база
own
ЄДОК,
registry, that's
офіційна база
HIDOC,
даних рішень Європейського суду.
official
Там містяться
database
абсолютно всі
of the
рішення, ухвалені відповідно
ECtHR
всіх
decisions.
держав-членів, в тому
All
числі.
decisions versus all states are present there, and there's translations into Ukrainian or that are provided by the Secretariat of the Ombudsman and the services. Yes, I understand, Doc, but I'm thinking of a Ukrainian registry.
Також містяться
The
рішення
website of the ministry also includes the decisions
під
of
реєстром.
the European Court. What do you mean?
Додатково, окрім самого рішення,
Ні, тільки саме рішення.
рішення опубліковуються також на сайті Міністерства юстиції. Так, у нас є окрема посилання.
Тематично. У вас
And
тематично.
this is thematic, and you have a general list. Well, yes, this is the thematic list anyhow. Okay, thank you. Thank you. As I was listening to Alisa, we were in the bomb shelter.
Як розроблено законопроект про юридичне визнання одностатових партнерств. Як пан Гудима нам розповідав про складнощі перегляду через 10 років, мені здається,
Mr. Hudima told us about the review next year, but I think we're a unique country, which despite the fact that we're progressing like this, so we are still progressing or making progress, starting from the conditions of imprisonment all the way through to gender issues. And it seems to me that after the end of the war, a lot of surprises are laying ahead for us, how the gender issues have affected the society, how they manifested themselves, and this will be interesting from the standpoint of gender and the war. I would like to give floor to the judge of the Cassation Criminal Court in the Supreme Court, Ms. Nadia Stepaniev, and she will tell us about the topics of war, women, and gender. You have 15 minutes.
чи можна нам запустити презентацію?
Can we launch the presentation? Okay. While the presentation is being launched, I would like to thank you for this invitation. I would like to thank the organizers, our National School of Judges of Ukraine, thanks to which we have started working and we have started studying the convention. This is how it was, and the judges used to treat the convention slightly differently in the past. But now you can see that we're applying it, we're discussing it. You can see that the points have changed, and this is a living organism, during which, as Irina said, we can move from one set of issues to another, to even more important issues, like the matters of gender. I was thinking about the name for my presentation for a long time. The right for fair trial is the right for gender-sensitive court. In the past, it seems like that gender is not on top of the agenda, and it's not very important, particularly in view of the European conventions. It's as if, nothing was said there. Now that we have armed conflicts, now that the gender issue is on top of our agenda, we can see that there's a lot of burden on the shoulders of our women. We cannot really call them the weak gender anymore. And I think this matter will be subject not only for the European Court, but we have to resolve these questions because these issues are very sensitive in our society. I just don't know how to switch the slides. Thank you. I will elaborate on several matters. On the matter of women and violence, because this also is very important at this point. The proof of such point of the facts of violence, taking into account the vulnerability of victims and witnesses, because usually the victims of violence is the major part. I don't want to provide the percentages, but the vast majority are women, children, and the elderly. And it's very important to make sure that we understand this in the judicial system, in the court system. Thank you. Next slide. We already know that that ensuring the right for equality, well, I spoke about this and I read this in a book that was published by the National School a long time ago, ensuring the equality of arms. Equality of arms when you're proving things, this is also equality, and this is a principle that is included in fair trial. Now we're talking about the right for equality between men and women, and amendments to the law will be made shortly with the right for a gender-sensitive approach in court, and it's an inseparable part of the fairness principle towards which the justice is geared. Why is this so? This is manifested now when we are considering the cases related not only to domestic violence, not only to gender-based violence, but also to the violence that is causing the loss of life, like murders, heavy bodily damage, etc. These cases have a very strong gender aspect present. The European Convention itself, next slide.
Сама Європейська конвенція з прав людини є гендерно-нейтральним документом. От я це також думаю собі, а чому вона така?
The convention is gender neutral. Why? Because it's the European Convention. It's the document that cannot really use gender-specific language, because in a different case, you'd probably have to have additional interpretation to each comma and full stop. What they meant when they said this or that. And we have the ECtHR, which has case law, which protects the rights of women, which is protecting vulnerable people, and it identifies the principles of access to fair trial, equal access. And specifically, we talk about equal access of women to fair trial, and also prohibition of discrimination. There is a general protocol to the convention talking about prohibition of discrimination, and we can see that in the list of different features is not a race, or skin color, or religion. And that's not by chance. The first feature, the first thing that's prohibited is the discrimination by gender. That's the fundamental thing in the European legislation. Why this is important? Why the language matters? I remember we once said that a judge does not have a gender. And I use Ukrainian words with feminine endings when I call someone a president of the court, because men, they identify themselves as people of masculine gender, and therefore they write president in the masculine gender. And my colleague complained that people hated her so much when she uses feminine gender for the word president. And they say, well, now you are more a woman than a judge or something. So I never thought that people can have that kind of mindset today, but apparently they can. So the language, gender sensitive language, matters, because we identify ourselves not just with the position we occupy. We have some social roles in the public, in the society. We are born who we are. And then we become prosecutors and judges. But this does not mean that we are supposed to lose our identity, which we get from our birth. That's about the language. Next slide, please. This is a classic case, Opus versus Turkey, where the ECtHR has found that access to justice cannot have any discrimination, and domestic violence is gender-based violence, and one of the forms of discrimination. So the court was able to tie together women, violence, the responsibility of the state with regard to access to justice and judicial protection, and fair trial. At the time of the armed conflict, we have a lot of violence, not just domestic violence. Mostly it's GBV. And mostly it's the violence which is connected to migration and the armed conflict, and migration of people and lack of protection, not just on behalf of the state. I'm talking about general support from family, friends, because the situation today is very difficult. Many women don't have that kind of support, and they have to help themselves. And they become vulnerable. So we as judges need to understand this. And every woman during conflict becomes vulnerable, especially those who are alone, and especially those who have children, and they're supposed to protect those children. And they just do not feel themselves protected. Next slide, please. So that was a classical case. Now we want to continue discussing the topic of fight against violence. And I want to point out this important case, Aremia and others versus the Republic of Moldova. In this case, they said that the government failed to perform its duty to protect the claimant, the individual, from violence. The investigation was not effective, and instead they discriminated against the initial claimant because of her gender. So the representatives of government, they mistreated the person who complained against this violence. They said, well, maybe it will go away, and maybe she will not come tomorrow. So that was clearly mentioned by the ECtHR. So next slide, please. Now, the case from February 10, 2022, A and B versus Georgia. Now, it's about passive treatment, passive attitude to fulfillment of duties as the state. And that did not allow to effectively investigate cases of GBV. The court found violation of Article 2, the right to life, because of failure to meet positive obligations, and violation of Article 14, prohibition of discrimination. The case was difficult. We are talking about a police officer who killed a person without any proper response from government. So this is a document, or this is the case which we may use in our practical situation, because we have similar cases. There was a case where the police officer committed violence. Now, the following slide, that's the opinion of the court. The court says that failure to properly evaluate the level of actually committed violence may have a harmful impact on the perspectives of opening criminal proceedings, and may also prevent the victims who suffer from certain societal pressure in the future to report about the abuser who is a family member. So, they say it's about family, it's a family case, it's domestic violence, and that is the exact case when law enforcement and the government are not capable of providing proper investigation and help. Now, another case, one case is C versus Romania, and then MM and ZM versus Ukraine. This is about violation of the right to private and family life. So again, S versus Romania case from 30 November 2022, and MM and ZM versus Ukraine. In this case, the court found violation of Article 8, but in the first case, they talk about violation of positive obligation of the state, where the government failed to effectively investigate sexual harassment at the workplace. The employee complained regularly that the supervisor was harassing her, and she was fired from her job, and there was no proper investigation. It was not effective, therefore she applied, or complained rather, to the ECtHR. There was another case, the case of MMZM versus Ukraine. It's talking about ineffective investigation of domestic violence cases. Let's look at the following slide. Now this judgment, RB versus Estonia, says that there was ineffective protections on behalf of the state. And they talk about ineffective investigation. So when we closed the criminal proceedings because of lack of evidence. Same case. So you see that there's been violence. You see that there is evidence, but the investigation was held in such a way whereby all the collected evidence constituted a violation of the evidence collection process and the presumption of innocence. So the court always between the rock and the hard place. We always say, okay, so we either acquit or convict a person. The judge will then think, okay, what if this case goes to the ECtHR? What kind of judgment ECtHR will make? Are they going to say fair trial or unfair trial? I think it's a huge advantage that the judges have this mindset. Before they said, yes, we acted by law, by Ukrainian legislation. Now everybody understands that there is the ECtHR and they will evaluate the fairness of trial in general. And here I wanted to discuss some of the questions which my colleague Dmytro discussed. Did it impact? Could it have impacted the fairness of judgment? This is in the Code of Criminal Procedure. And we come across this problem every time when we look at the criminal case. Have there been some serious violation of the procedural legislation or not? Whether the serious violations, and the law says the court judgments are subject to repeal if the lower instance courts allowed for serious violations of the criminal procedural legislation, which could have impacted the legality and justification of the court judgment. Now, it could have impacted or impacted. That's the language they use. Not a very complicated question, to be honest. Because we cannot really say it could have impacted. You know, if there was an impact, then that's it, we say it impacted. If it could have impacted, we repeal the judgment because in this case the lower instance court did not evaluate properly. They violated seriously the requirements of the Criminal Procedure Code, which could have impacted the legality of judgment. However, maybe next time, the following judgment will not be different much from the previous judgment, but that serious violation gives us grounds to say that this judgment can be repealed and sent for a new trial, or we may just completely abolish by issuing the appropriate judgment. Next slide, please. And now I'm gonna touch upon the armed conflict, where I started actually. I said that during the war, women take up all the risks. They are responsible for the families, for the children. And then you have the rape, you have sexual violence against women, especially in the temporarily occupied territories. It's been recognized. It's a military tactics that they use. That's another type of ammunition that they use, like a missile. Because who are not protected in the occupied territories? It's women and children. Therefore, we have those cases. You know, these cases are not being investigated. The cases of sexual violence against women. Then there are court hearings which will happen, and in this case, the judges have to show some sensitivity. The investigators also, not just the judges. Not everybody would want to talk about the atrocities they lived through and everything that happened to them. With rape, usually we know it's a very difficult type of crime, and we don't want to re-traumatize the victim again. And when we talk about this kind of crimes committed by the aggressor, that is extremely difficult. Next slide, please. Now, at the same time, we have the question of admissibility of evidence. So, eyewitness testimony, then open source information, published in social networks. Sometimes you see pictures, sometimes there are some TV shows which we all watch now. What's the admissibility principle here for the courts? And it's connected to the ECtHR case law very closely. Now, next slide, please. So we have this very important tool. It's called Berkeley Protocol, and it's a recommendation. Back in 2020, it was introduced by the Berkeley University in California and the High Commissioner of the UN. So this is where we talk about the process for collecting of evidence, also using open sources and how that information can become evidence in a criminal case. Our General Prosecutor's Office is using this protocol for collection of evidence. And also with them, there is the Bellingcat organization that's working very hard on collecting evidence, but we're talking about general approach. Let's say you have a case, let's say you have a judgment. How do you evaluate this kind of evidence from the standpoint of the right to fair trial? and the presumption of innocence, and admissibility, adequacy, validity of evidence. It's all a part of that. I'm now trying to rush because we want to make sure we finish on time. So the ECtHR does not have a case law. They don't have a specific case where they would use the Berkeley Protocol for investigations. But then there is the general requirement of the European Court with regard to fair collection of evidence. And we do have some experience. So on the next slide, you'll see the judgment where it's used. So it's Georgia versus Russia case. In this judgment, the European Court referred to, so they pretty much made the first step. They referred to the satellite high-resolution imagery in the conflict of Southern Ossetia that was published by the AAAS, and the ECtHR found that the analysis of satellite imagery in their report has become objective evidence with regard to issues to be decided upon in this case. Now, what the ECtHR was guided by? They were guided by the fact that this American Association for Assistance of Science, they are very reputable globally. This is the organization which would never allow to falsify data like that. The data which then they collected from the open source. Now, this evidence became admissible. The reputation of the organization made evidence admissible and objective. Next slide, please. So coming back to gender-sensitive terminology. You know, I'm reading the judgments. In many cases, they do not use gender-sensitive language. You know, we look at the situation, we look at specific cases of violence, and it's not there. When I look during the appeal procedure at one of the cases, I saw that there was a complaint in this case. And the complaint was looked at for such a long time. And we're talking about bodily harm. So no one, it was the case when a man caused bodily harm to a woman. No one ever said that it was gender-based. No one said that it was domestic, because they were ex-husband and wife, so they treated it like a regular case. On multiple occasions, the Court of Appeals called, summoned the victim, and she got sick and tired of those summons and visits. So the abuser got a very light sentence. So the claimant said, let's just close everything. You know, I fell and I got hurt. So the victim herself asked to stop all the proceedings and close the case against the abuser. And I want to give credit to this appellate court because they repealed the first instance court judgment. They reevaluated evidence. They also reevaluated the circumstances of the case. And they said that her request to stop the case is in contradiction with all this evidence and her evidence provided in the very beginning. So, you know, it's all about the adoption of proper gender-sensitive approach to hearing cases. So this gender justice picture is very good. I really like it. You know, what this is, it's about gender-sensitive cases, it's about gender-sensitive court and gender-sensitive court judgments. And in this case, we will have balance. And we will understand that now, finally, our courts are fair and just. Okay, thank you so much. Thank you. I have a quick question. So this gender-sensitive court, is it about the members of the court also? Men and women judges for some categories of cases? Well, speaking about the membership of, yeah, I want to be very specific. So with the Court of Appeals, you know, this father asked the court to decide on the place of residence for the child. So the father said that 3 members of the court are women, and he decided to have different composition of the court. He said it's not gender sensitive. Yeah, I think that request was not accepted. A different judge got the case. And the panel of judges, they just do not know, you know, which gender they associate themselves with. See, it's a really difficult question, where they confuse gender and sex. I remember that, you know, I was young and they said, well, this young woman doesn't understand anything. Because they would say, yeah, had we had a man as a judge, he would probably come up with a better judgment. So people somehow believe that your judgment depends on your gender. So yes, that request to change the members in the panel of judges, that was refused. Yeah, but why they decided to give the case to a different judge? Well, when this request is not satisfied, then it's a procedure. Yes, they just give the case to a different judge. I would not give the case to a different judge. Well, we just have this procedure. If we have an unjustified request to remove certain judges from the bench, then it's sent to a different judge. Yes, yes, that's what we have. Well, okay. When I talk about gender-sensitive court, I'm saying that it's supposed to be sensitive to everyone, not to just specific women or specific men. It's to everyone. It needs to be sensitive to the needs of everyone, children as well, right? We also have that. So it's about understanding and going deep into the problems of each and every person, participant. You know, in that case where you said there was a victim of domestic violence, men, when, you know, they are accused, you know, they say, well, she was yelling at me and whatnot. And sometimes she applies physical violence, you know, she beats me up. Why? Why men use physical violence against women? We just have to understand, because women, they are not protected physically or financially. Mostly, they don't have that ability to make money. Psychologically, especially when you have children, you know, you are thinking differently. You know, it's like I better suffer because I will still preserve my family. You know, that's gender-sensitive approach. What about men? Men become victims as well. You know, psychological violence, it's still there. When woman constantly demands that, you know, he does something, you know, maybe she is jealous all the time, and psychologically it creates a pressure. So the judge needs to be prepared for this. The judge needs to understand the violence cycles. We had a very good course in the National School of Judges. Tatiana, you probably remember, right? I think we visited Bosnia. Well, I suggest we answer the second question. A quick reflection about crimes, sexual violence. I'm using stats from this year. So we have 252 cases. 257 about women and 95 are about men. Especially considering the latency of this kind of cases. And I want to speak about the freedom of movement. And we have this question on the table, because this question will have to be somehow decided on illegally. There's right to leave or prohibition for men to leave the country. All these prohibitions, they refer directly the law on mobilization, training, and something else. They just refer this law specifically. And in that law, mobilization law, they talk about men and women equally. And we also have women and men who are registered as fit to serve. But mostly, this restriction is about men. And then there are high-level officials, there are people who have some protection from mobilization. So this approach, potentially, will it create the grounds for raising the issue of gender inequality? Right? Outside of all this, psychological and other things, using the mobilization law and the applicable criteria, this prohibition is a way of discrimination, I think. Discrimination against men. They are more discriminated than women. So I'm not saying that women always suffer from discrimination. Men suffer as well, like you just said. That's about the gender-based violence, war-related, conflict-related violence. There is so much violence against the prisoners of war. Then there is violence against servicemen. That will all be revealed later. So any kind of discrimination needs to be punished, prosecuted.
Since I'm a criminalist, I am the one sort of following it. This question, I believe, can only be resolved through training, gender sensitivity training, both for female judges and for male judges, so that they could properly write it in their statement. I realize that they have probably written it all correctly, but with reference to international standards, that regardless whose mentality, who is wearing the mantle, man or a woman, they have to consider cases. I am not a military, but I have to consider war cases as well. It doesn't mean that, category of cases makes you be a specialist in a specific field. I think judges were very lucky. We get to know all kinds of things from all walks of life. And we know and we understand a lot of things. And the European Convention's provisions help us understand that a lot, as well as the ECtHR case law, which at the moment have become a very important factor. It has become a very important marker in decision-making, so that we understand what is the court, what are all these, what is this fairness? And this is this internal provision. It's written in the laws in a pretty dry way. But this is all about fairness and justice in the broad sense of the word. I think Ukraine will still have to learn the practice of the case law. We are out of timing because of the air raid, and I cannot but give the floor, albeit briefly, to the expert who will help us delve deeper into gender-based violence and discrimination. Tatiana, the National School of Judges of Ukraine. Thank you. This is a great honor for me to be in this room. This is my 10th forum. My first presentation was related to the right for fair trial. And when the general questions of prohibition of discrimination was outlined, today we're talking about the challenges of war. And a lot of questions have already been raised during the previous discussion, during the presentations of Nadia, during the questions that were being asked. Yesterday, Judge Hnatovsky and Dmytro Tretyakov from the Secretariat remembered Konichenko versus Ukraine. And we will be monitoring the progress of this case. But the matter in this case, besides well-familiar issues that have been raised by the ECtHR in the cases versus Ukraine, this gives enough ground for the limitation of certain rights according to the national legislation, where interference had sufficient background in the national legislation. So it was happening according to the law, whether or not the law was meeting the quality criteria, whether or not there was intervention in terms of proportionality, was it proportional to the requirements of the democratic society, given the individual situation of the applicant. So besides these questions, the court has asked the government whether or not they believe that the treatment of the applicant was discriminating in terms of gender. It was based on the complaint of the applicant because the applicant was not only complaining about the violation of the freedom of movement, but also on the violation of this right in the context of violation of Article 14 and in the context of right related to the freedom of movement. This is just one of the examples where the war has simply highlighted the existing problems that have some legal perspectives through the prism of gender. If we remember the months preceding we all remember the statement of the leader of the aggressor state, whether I like it or not, you have to be patient, my beauty. And this address, my beauty, was perceived unanimously as the one referring to Ukraine as a woman with gender-related connotations. And those gender-different practices of torture practices where men and women were handled differently, they were humiliated differently, including the situation with gender focus. For example, when women soldiers had their heads shaven. Sexual violence related to the conflict is a method of conduction of war. Besides other situations that are very frequently mentioned in the public space. It means that among the persons who left Ukraine, what we are calling, refugees, more legally appropriately, persons who receive temporary protection. Most of them are women with children, and their further fate All of this shows that the matters that were perceived as background in the past before the full-scale invasion, all of this is showing that these questions are a lot more pronounced right now. I would not like to turn this presentation into the list of pictures of the life from the life of applicants, but I would like to outline these points in a more global aspect. First, are gender issues and gender discrimination prohibition matters important during the times of war? Secondly, is it important to use the gender prism? And thirdly, why is it important to analyze and understand the manifestations of inequality and approach the analysis while using the gender component? As we're presenting this book, Behind the Curtains of the Empire, the Supreme Court, by the way, had a very good initiative once upon a time about 5 books recommended for reading. Vera Aheeva, I don't think we need to introduce her further. She was asked a couple of questions. One of the questions, she was invited to the events on gender-based violence, and you rejected this because you said this is not a timely matter. And she said then, whether or not the context is important. She said, I do not believe that the matters of gender-based violence are not important, but taking into account the time and given the fact that human resources are limited, for herself personally, for the person who was standing together with Solomia Pavlichko, launching the question of gender equality and feminism in Ukraine, in the Ukrainian cultural space, who wrote several books on feminism, who has a YouTube channel called Crazy Female Authors. She focused a lot on this, but she said that for herself, personally, at that very point, and that was August 2022, the matter of post-imperialism, post-colonialism, and what we do with that discourse was a lot more important for her at that time. Given the fact that over the past 10 years, the matters of liberal values and gender equality received a lot of attention, probably more attention than the post-imperialism. And that was very important. Second point, why is it important to use the gender prism? Oksana Zabushko helped me find the words for it. And again, this was in the context of war. And it seems to me this happened at the Lviv Forum. She was answering the questions, why is it so hard to deliver our words to the Western world? Why are we being forced to take on certain discourses? For example, the fact that war transforms people into beasts. She said that while answering this question, she said that, let me try to formulate this for the first time. This is universalization of experience. What happens now is the universalization of experience of World War I of the imperialist state. So I would say it is a great thing for Ukrainians to study feminism, because feminism has discussed a lot about deconstruction of that philosophy of arrogance. It has outlined the patterns based on feminine and masculine, on the example of discrimination of big groups, on which it's not clear how it works, how you can marginalize the experience of statistical majority at the account of power-based privileges and universalize the experience of the minority based on the same privileges. And this is a very important experience. And in the experience of the war, the same things are happening. And now is our time. It is the time for intellectual Ukraine to tell the West, no, guys, that's not what you were thinking to yourselves. It's just that you were Russians for many years. You were leading those wars for a very long time. This is your experience, and Ukraine is fighting for independence now, basically, and it has a slightly different background. And the third point, why is it important to discuss this and to talk it through? Nadia mentioned the aspect of violence as a criminalist. She had more of a violence-based component. And we're talking about the upsurge of violence, domestic violence, and generally aggressive conduct in the society. And a lot of experts are saying just that. Violence also generates inequality. And the sense of inequality leads to the increase of violent behaviors. That is why we need to be able and should be able to identify those manifestations of violence. And at the end, I would just like to give an example of our 10-year experience as to one document that we in the National School of Judges, during the trainings in gender-based violence and prohibition of discrimination, one of the examples, one of the exercises that is being used for training purposes is the analysis of one government document, which was born at the same time as this forum, adopted in November 2012. And the government adopted the concept of the state program of ensuring equal rights of women and men from 2013 to 2016, I think. And the importance of this concept is based on the fact that the government back then, and this was done by the government, and the government has stipulated 7 manifestations of gender inequality. 3 among them were related to a huge gap in terms of representation of women in decision-making authorities, in political, economic, and socially important decisions, a de facto gap in the labor remuneration between men and women, and the gap in terms of economic activity of women. These were the first 3 manifestations of inequality. Inappropriate balance of combination of professional and family duties, overcoming gender stereotypes, and there was even a government strategy adopted further down the road, the use of sexist advertising, and the presence of the facts of discrimination based on gender. These 7 manifestations were used in various ways. We were discussing this with judges during seminars and trainings, and over the past years, since the program was not valid anymore, and the concept was not valid anymore, there was a question, what manifestations do you think are still relevant? And which of the manifestations do you believe are irrelevant anymore? If we could briefly formulate several opinions, I would present them in the following way. What is important for some is unimportant and invisible for others. For example, about the combination of family and professional duties. It should be the people investing their actual time in those duties and their harmonious combination thereof. Usually, they cannot carry the load equally on both sides. We can also see that the progress, and we cannot deny the progress that happened over the past 10 years, the progress thanks to legislative changes, thanks to societal changes, it is interpreted in a rather odd way because, for example, when the number of women in parliament has grown from 7%, which we had during the adoption of that concept, to 19%, then this significant progress was being assessed. Well, the question is not relevant anymore, but the representation has grown by by a factor of 3. It does not even achieve the 40% quota. And the fact that Ukraine is unfortunately much lower than the majority of the European countries and even multiple Asian countries, it is still perceived as some kind of progress. So we have some progress, and that's irrelevant anymore. And I think we need to reflect on that as well. Another point. This is what Nadia started saying. Gender is still perceived through the prism of biological determinism. Gender is not about physiology and not about biology. We have ratified the Istanbul Convention already, and this already happened during the full-scale invasion. This is the document that stipulates the definition, and we know that gender is actually about social roles, about the roles that are seen appropriate in a certain society for men and for women. And the connection between gender and the power, gender and money, gender and the difference of labor remuneration is very, very invisible, and it is not obvious at all. At the end of my statement on Istanbul Convention, despite the fact that its name officially states the Convention on Prevention of Violence Against Women and Domestic Violence, it is not only related to women and not only to domestic violence. Article 6, using this opportunity, I'd like to focus on that. It is written in pretty abstract formulations, but it actually holds very strong philosophy and practical steps. It is based on the fact that the parties must include gender-based aspects in their documents and effectively pursue the policy of equality between men and women. And to end with what we started, Konichenko case, these cases are actually showing that gender is not just about women. And we have stepped away from the concept of men and women. It is about social roles, which the society believes is important for both men and women. For example, the example of Konichenko case shows us only one aspect of border crossing, or how do we call it? The implementation of the realization of the freedom of movement or the inability to do so. So men are choosing very interesting strategies. The concept of responsible parenthood has never flourished so vividly as it did over the past year. If we take a look at the facts of the case, based on the facts that are legally related, these facts match the circumstances stated in Article 23 of the Law on Mobilization as the foundations giving the postponement of mobilization. Therefore, the court should be ready to respond. In consideration of these cases, the court should be able to see this gender-based perspective, and they should be able to implement this multi-stage test. And whether or not there is an unfavorable attitude and on which foundations, compared to whom, do we have some illegitimate goal? Should we take into account the ways of ensuring this legitimate goal? Are they sufficient? And only then decide whether or not there was discrimination. And the court, the national court, still needs to consider these matters further. And I think there will be a lot of such cases. Thank you. Thank you. Any questions? Okay, I don't see any questions. Okay, my question is more of a reflection. Given the topics that are stated in our agenda on the challenges in the times of war, we can already see them, but I think we would only be able to see the results at the end of the war. Hopefully the war is over soon. Given those challenges, women whose husbands, whose children went to war, they basically are standing next to them, regardless of which functions they are performing and whether or not these women really are in the armed forces. But or are they, leading various funds and volunteer organizations? And these women, particularly, sad as it may seem, they will not fold their arms and they will not want to sit at home when the war is over. Relatively speaking, this may not be, it's basically like a genie in the bottle that we cannot put back into the bottle. And the state must already think, or better yet, it should have thought of this yesterday. The state should think how to involve those women in the country's development, how to engage them. This is not the matter of their work in a certain state authorities, but it's a matter of using their potential, their existing experience. Tatiana mentioned economic equality, for instance. It's important to enhance that economic activity and the capacity of the state through participation of women in the development that we all believe will start as soon as the war is over. Thank you very much, Sergei, for this comment. I'm also deeply convinced that in any case, we cannot go back to the 23rd of February 2022. This is just not possible. The country is not going to be the same. Equality doesn't mean uniformity, and we're thinking about the procedural rights and duties. The parties have equal rights, procedural rights, but they are not identical. The applicant can file a lawsuit, can recall it. We were talking about the principle of equality of arms. It's a very good analogy. Equality is not an antonym to inequality, but not to uniformity. The state should really think about certain strategies and specific steps on how to best involve the economic and intellectual potential of both men and women. Not all men are able to fight. There are women who are able to fight. Not all women want to do the job that is called sort of caretaking. And for some reason, society believes that it's inherent to them from birth. It's kind of congenital condition. But men and women can be involved in the same situation, and this is a matter of our survival and our future. I suggest we move on. It's a great honor for me to give the floor to the next speaker. It will be online. This is a legendary person, the professor of the Department of Philosophy, Ivan Franko University, Mr. Petro Rabinovich. Thank you. Thank you. I have very special emotions about being present here at this event, because in my life, there are not many of such events where the initiators and organizers, where I organized the first ones, the launch events for these. I think in 2012, 3 persons, me and 2 of my postgraduate students, for the first time in the history of Europe, definitely for the first time in the history of Ukraine, we've organized in the territory of Lviv University, as they inappropriately said. I then spoke against this formulation. We've organized this international forum on the practices of the European Court of Human Rights. In the case law, Mr. Dmytro Gudima, who perhaps among all of our former graduates and postgraduate program students, my postgraduate students who participated in this forum most frequently, Mr. Taras Pashuk, who was working in the secretariats of the ECtHR for more than 10 years in the sort of Ukrainian team. The 3 of us organized this for the first time in the country's history. And it was an amazing event at that time. There was nothing similar to it, neither in the ECtHR nor in the current domestic practices. And now is the 10th year on. Only last year, OSCE, I think, did not organize this event. And I would explain my assessment of this, that I've raised about these emotions. Regarding my feelings, I'll make a small note that I am personally particularly thankful to Ms. Natalia Stepanivna Stupnitska, who contributed the most efforts to make sure that this event happens at this level at our university, where the way we're used to see this, where it builds certain traditions, and where she contributed so much effort at such a high organizational level, and I believe that we can call her as among the first organizers, and we can mention her name among those thanks to whom this event has become so popular as to becoming its participant. Becoming a participant requires a certain competition with different methods, criteria. The organizers have tried different methods to make sure they could select the best people for the work, practitioners, judges, teachers who are working at the ECtHR. We could meet many of them in Lviv.
In the building of the ECtHR, on the ground floor, they have this lobby with lots of information. And there are 3 brochures in that lobby, which became the foundation for further translations of press releases of the ECtHR, and then complete judgments. So that was back in 2017, 2018, 2019. So those brochures with information, and my colleagues mentioned on many occasions. They still saw those brochures on the first floor. They said that this Lviv legal lab, which was established upon my proposal back in 1996, is still live and kicking, as they say. It was built based on the appropriate decision of the Academy of Legal Science of Ukraine. So that was our contribution, the contribution of our lab into the founding and functioning of this forum, international forum of practitioners who discuss everything that's related to ECtHR case law. And I'm very happy to know this, and I'm happily participating in this conference. And that gives me pleasure. And Dmytro Gudima presented today, who is a judge of a grand chamber from the Supreme Court. So I was very pleased to see him. So people know what's happening. People know how we work very hard to work on our presentations. And I will try to make my presentation very quick. So the co-author of this report was him. And Tamara Ivanivna Dudash was helping. He's the associate professor in our chair. And she works on a very unique topic, which never was properly researched in Ukraine. And she is aiming to become a doctor. I'm just giving comments now, but these comments, they illustrate the fact that how much attention is paid in Lviv University, and the Academy of Legal Sciences is spent on protection of human rights. So the issues, the problems that are connected to human rights. And to not take too much time, I wanted to mention a few words about this very unique topic, which we started to raise for the first time internationally. So these are called consultative opinions of the ECtHR. The term itself appeared a long time ago. There are 2 articles in the convention that are dedicated to these documents. So when Tamara and I discussed it, we were asking ourselves, what can we tell people on this matter? What can we tell this gathering? And I decided that consultative opinions need to be discussed more widely because our national legislation doesn't have that official term. It's not in our legal tradition, not in our legal history. So when the 16th protocol became effective, I think it was 2018, and the creation of the consultative opinions became quite a special process. And Alexander Pashuk, he worked as a senior lawyer for more than a decade in the secretariat of the ECtHR. So at each and every forum, every year we would get behind the scenes and discuss things eye to eye. Now we would share our impressions about the work of the ECtHR, about the discussion of human rights as a research topic in our department. So we would kind of sit separately from the rest of the participants and just discuss things. I didn't know whether he's listening. Because as far as I remember, I think for 2, maybe 3 years, he has stopped working in the ECtHR. But then every year he congratulates me on the occasion of my birthday, and that's a good thing. And when he defended his thesis, his dissertation actually, he gave me a disc with recordings of my lectures when he was a freshman in college. So he recorded, and when he defended his dissertation, he gave me a disc with my lectures on the theory of law and the state. You know, I somehow remembered that. So Taras is now working in the Venice Commission. And when he went there to work, he said, look, for me, I don't see anything new in the ECtHR case law. And I started to lose interest in this kind of work. And from this young age, he had this urge to get new information about his profession. And his wife, by the way, also graduated from our department. They have 2 children, 2 boys. But it's not about that. These consultative opinions, you know, they are quite special. Is it a legal act or not? Because people who are present here, they probably would say yes. If it's a legal act, and there are several types, then what type of legal act this is?
Ми з нею проговорювали це питання. Ну, я сказав, що насамперед це правотлумачний акт, чи акт офіційного тлумачення.
So,
Нюанс полягає
there is one little nuance.
що офіційне тлумачення
Official interpretation
має рекомендаційний характер.
is of a recommendational nature.
Акти офіційного тлумачення.
So have you seen any legal acts that are of recommendational nature? Have you seen anywhere legal acts of recommendational nature? And here is the point which I wanted to make.
Вся ця епопея
All this long story with the European Convention of Human Rights, and this is not the official name of the convention. All this long story with the convention
своїм існуванням, своїм виникненням. І тут я дозволю собі припустити, що більшість присутніх цього не знає.
is unknown to many people who are present here. And there was one student from the same department which I graduated a long time ago. The department that Tamara graduated from way later than me. So the last name of this person is Professor Hirsch Lauterpacht. So he is very much connected to the establishment of this convention. He has a fantastic book which was published in the spring of 1945, before the end of the Second World War. And Professor Lauterpacht also had a role in this. So 4 unique articles in the document, based on which over 20 persons were sentenced in Nuremberg on the second floor of the municipal court. In the town where the Nazi party was formed, where they paraded in front of Hitler. So there are so many little-known facts. And this professor formed these 4 types of corpus delicti, types of crimes against people, against humans, which were replicated verbatim, and very few people know about this, replicated in the Roman statute, very wonderful name, Roman statute of the International Criminal Court. And you know that this court actually issued an order to arrest the president of Russia. So Professor Lauterpacht did so much, so many important things, and now globally he is known as one of the most influential lawyers of the 20th century. That's how he's recognized. I think he's the legal genius, that's how I call it. Because he created so many wonderful things. And the corpus delicti that he described for crimes against humanity are copied in the Roman statute. That has almost never been done before. Then secondly, it's important to mention that he has become the first unofficial doctrinal developer of one document, which was called the General Declaration of Human Rights. So in his book from 1945, which was brought from England by Philip Sands and presented to me. So that's the copy published in 1945. So one of these chapters, there are 220 pages, and one of these chapters is called International Component of Human Rights. So in 2014, this work was published again. Philip Sands organized it in English.
нормативного акту з преамбулою і 24 статті. Кожному члену робочої групи,
So there were 24 articles,
це половина комісії ООН з прав людини.
and we are talking about half of the UN Human Rights Commission, 18 members.
І цю робочу групу очолювала голова цієї комісії, вдова колишнього президента США, який єдиний в історії США.
The widow of the US president who got re-elected 3 times. Everybody else was re-elected twice, but he was re-elected 3 times. President Roosevelt.
Дружина Елеонора очолювала комісію ООН з прав людини, яка, ви знаєте,
So Eleanor Roosevelt, she was the chairperson
ООН з прав людини.
in the Council, UN Council for Human Rights.
Виключили Російську
And the Russian Federation was removed from this council.
Там було написано в резолюції Ради ООН з прав людини, яка зі свого складу
The UN Resolution on Human Rights,
сказати. Правда, росіяни і самі вийшли
they sent away
з тої зали,
the Russians. They left the room where the commission met. And it's in Europe, it's not in the building of the General Assembly in New York. So the Russians are gone in OSCE, as you know. The Russians are now participating. There will be yet another session of OSCE, but it's a different story.
У вас ще цілих 5 хвилин.
You have 5 minutes left.
Дякую. І ось, ви знаєте, шанувати людей, завдяки яким виник Європейський суд з прав людини.
So the conditions for the establishment of the European Court of Human Rights, the European Convention of Human Rights, you know, all that is important. And we have to mention Professor Lauterbach, who was born in one of the towns in Lviv province. And there are 3 memorials to this professor in Lviv province. And one of them actually sits in our law department, where Professor Lauterbach received his education. So I'm giving floor now to my co-presenter. Tamara, over to you. Apologies for taking too much time for all this. Thank you for your attention. Well, apologies, we cannot give you more time. Time is very limited. Okay, now thank you so much. We are giving floor to Tamara Dudash, who is the associate professor in the Department of Law in Lviv University. She will talk about the consultative opinions of the ECtHR. Now, please turn on the presentation. My presentation is going to be short. Very well. So this topic, the consultative opinions of the ECtHR. I just want to have a look at this through the lens of the fact that ECtHR started adopting them. And we have to offer some suggestions, some ideas about what their place is in the legal system of Ukraine. Next slide, please. First and foremost, let's talk about consultative opinions as part of Protocol 16 to the Convention, because there is Article 47 to the Convention, and there are 2 types of consultative opinions on issues, on matters that are not related to the human rights matters as mentioned in Section 1 of the Convention. Right. Just, to generalize the specifics of these legal documents. As Petro already mentioned, they are of recommendational nature for those institutions that apply with a request for the consultative opinion. Now, there are 6 in total. These consultative opinions of the ECtHR, they are marked as key case. Now, what is that? It means that the ECtHR is also giving them a special value, special weight in their case law. Also, all these opinions, they are adopted by the Grand Chamber And in line with Protocol 16 and case law for adoption of such opinions, the ECtHR is satisfying the request for adoption of such opinions upon condition that they touch upon principal issues of interpretation of convention. More to that, in the justification, the ECtHR sometimes provides arguments with regard to the legislation in a given country, for example, in France, is common with other states. Therefore, the consultative opinion will apply to indirectly to the legislation of other countries. So for the ECtHR itself, these consultative opinions are a part of its case law. And they are supposed to be viewed and recognized as such in the legal system of Ukraine. So that's a stepping stone. It's a part of the case law, and it formulates different legal positions, which we understand, interpret, and enforce. The courts are supposed to use it as the source of law in the same way as all other legal positions of the ECtHR. Also, we must mention, among many other things, that if we analyze the resolution of each and every consultative opinion, we see that they are not giving direct instructions on how to solve a specific case or how to judge in a specific case. They show an algorithm, a procedure for addressing a certain case, considering all of the requirements of the convention. And at the same time, they are giving answers to specific questions of the applicant. I want to make a quick reservation, and it's a part of my own observations. So, in the beginning, ECtHR, in its initial consultative opinion, provided clear answers to two clear questions. Now, later, based on the text from the initial opinion, saying that the sequence of questions may change and they may not provide some details, then they quite intensively started engaging into this kind of work. And I'll show it to you. But in the latest consultative opinion that dates back to 2023, upon request submitted by the Court of Finland, well, they somehow digressed from providing clear recommendations, from providing direct recommendations. And I will quote, they try to evolve in the process of formulation of consultative opinions and providing justifications. So on one hand, the competencies for provision of consultative opinions puts additional burden on the ECtHR, but the consequences that they get as a result become positive for the court. Why? Because this allows to use convention at the national level in the way which is consistent with the ECtHR case law, and it takes into consideration the specifics of the situation and also the provisions of domestic and international law in a given case, which the domestic court is hearing. So, by doing that, ECtHR prevents applicants from sending complex cases to the ECtHR. And then in the motivational part, in the resolution, all this wording, it just helps with the evolution of the case law of the said court. Now, I was supposed to tell you here about the circumstances of the case and the questions that are sent to the ECtHR and the responses of the court, their legal positions. But unfortunately, we do not have time for this. We are behind schedule, but I just want to quickly mention the subject which the opinions talk about. The initial opinion, and I don't think we need to focus on it not because it's unimportant, but because it has very good in-depth description in other analysis. But it's about France and surrogate mothers. and also about entering information in documents about mothers who were born abroad based on their birth certificates from abroad. So two questions were raised. It was the Court of Cassation. So two questions. And there were two answers. And then one more thing, this consultative opinion, it actually complements the legal positions in -1 versus France case, which was enforced, but it only partially removed the problem. For complete removal of the problem, they used the tool of consultative opinion. But yet again, that was the recommendation for complete removal of the problem. Next slide, please. Now, in 2020, upon request of the Constitutional Court of Armenia, the European Court has produced a consultative opinion with regard to blank referral method with regard to crimes and the legislation that was in effect during commission of the crime. So the title is very complicated and long, but in a nutshell, to simplify, this opinion is dedicated to bringing people to justice, specifically ex-president who lost elections, and there were protests, and someone was trying to hold him liable based on the law which was adopted after mass protests. And as a result of those protests, people died. So they retroactively were trying to hold someone responsible. And 4 questions were asked on this topic. ECtHR provided answers to 2 questions, saying that those blanket referrals during criminalization or omission is not by itself incompatible with the requirements of Article 7. Then there was another question. And the answer is kind of obvious, but still, for you to identify whether the adopted law, the law that was adopted after the commission of the crime, and whether it's favorable for the defendant, unlike the law which was in effect during the commission of the crime. So for that, you have to look at the specific circumstances of the case. And if the new law is more strict than the previous law, it may not be applied. Okay, so next slide, please. So the third consultative opinion is about impeachment. Impeachment of a parliament member. And the title is like this, the violation of Article 3, Protocol number 1 of the proportionality of the general prohibition to campaign when the person was removed as part of the impeachment process. Upon request of the Administrative Court of Lithuania, the ECtHR provided the response.
There's no chance to explain about the details about this, but in this context of this case, but the basis of the case is that the Central Electoral Commission has ignored the presence of the Commission of the ECtHR decision in the similar case as the case of the person whose case was rejected for registration, Paksas versus Lithuania, and this made it necessary to address the ECtHR for the advisory opinion as to whether or not to maintain and to keep those positions. The ECtHR has stated a position, and they stated clear criteria that are important to see whether or not the prohibition of implementation of the members of deputies mandate, the impeachment provisions according to Protocol number 1 of the Convention, Article 3, and they need to take into account the positions that led not only to the positions that the preconditions that led to impeachment, but also in view of the functions that the person plans to do in the future. The membership in the institution, as well as constitutional system and democracy in general, is related to the state itself, and this has to be observed according to the established criteria. Next slide. The next advisory opinion has also been provided following the request of the Armenian court. And Armenian Cassation Court made a very interesting decision because the need for its adoption was raised by the need to implement the decisions of the European Court for Human Rights. It was all about torture. The torture was admitted for a person, and police officers were brought to account for proceedings. And when their guilt was recognized, the statute of limitations has passed already at that time. And so the prosecutor has raised the question on whether or not there is statute of limitations for a violation of Article 3 of the Convention in the form of torture. And the ECtHR has given one answer to this. If the criminal case has a statute of limitations according to the national legislation and the time of limitation has gone, then the article of the convention does not allow to have this, and the court stated whether or not the norms of the law that have the rights in the national system, whether they can provide sufficient legal ground in the view of Article 7 of the Convention to give the opinion that for this criminal proceeding there is no statute of limitations. Next slide, please. This is the last consultative opinion that we will elaborate on, because if we go into number 8, that would be too much detail. Following the request of the Supreme Court of Finland, the procedural status and rights of biological parent in the case of adoption of a non-minor person. What was the person? The consultative opinion was issued on the 13th of April 2023. An aunt was watching the child all of her life, all of the child's life. She wanted to adopt. This was done through court, but the mother was against this. But the mother did not have a procedural status according to the national legislation. The Supreme Court of Finland asked the following questions to the ECtHR, and the answer to these questions was the same. According to Article 8 of the Convention, judicial procedures as to the adoption of the non-minor child can be considered as affecting the private life of biological parent. This parent has to have the right to be heard, and the arguments need to be taken into account by the person who is making the decision in the relevant to a relevant measure. However, taking into account broad freedom, broad sort of leeway, the observance of Article 8 does not envisage that the biological parent should be given the status of a party or the right to appeal the decision on adoption. If the court decides that the right which the biological mother was claiming, it does not exist even on a controversial matter in this, that means that Article 6 is not applied to the adoption of an adult child. We will skip another biological opinion. It's upon request of France. However, we will skip this because of lack of time. By way of summary of the last consultative opinion, Article 6 will not be applicable, and this is not just a recommendation as to the algorithm of case resolution, but this is about opinions that are more specific compared to others. If we treat this through the prism of consultative nature, taking into account their contents, their resolved questions, this is the right to interpret the act of recommendative nature. It is a result of official interpretation in connection to a specific case of the national court and based on specific national legislation. This is a component of the ECHR practice, and this needs to be reflected in the sense of understanding of this concept in the national legislation. This is not defined enough, as far as I'm concerned. If we look at the features of the arguments in the consultative opinions, we can see that the structure of the decision itself is different. The structure includes prior deliberations where the ECHR states about the practices. The legal provisions of the ECHR are reviewed in the similar cases, as well as arguments from the prior consultative opinions, advisory opinions, particularly in the section where there's prior deliberation of the ECHR. The ECHR deliberates on the prior European consensus onto the boundaries of the state's intervention, as well as consequences in the consultative opinion of the request of Finland. Supreme Court, the ECHR has also ruled that whether the criminal law of the Council of Europe's member states is stipulating these norms, blanket norms, reference norms. 3 out of 6 advisory opinions had a definitive role of the presence of the similar decisions of the ECHR decision. One of the consultative opinions also has a minority opinion of a judge based on Armenia versus the Constitutional Court. I would like to summarize. I was in a rush, and I apologize that my presentation was somewhat rushed. I would like to summarize that the opinions of the ECHR, in my opinion, are a very powerful tool of convention interpretation that will have their own development, given how the rights are registered in terms of their address, their provision, and given how the court treats those opinions. If you need, I have more materials on that, and I'll be happy to provide them in more detail if you'd like. Yes, it would be great to have those materials because we will be summarizing all the materials of our speakers, and we will send a mailing list for the participants. Any questions? Yes, please. I'll be brief. Do you think that opinion can be applied to other states? The state other than the state in question? Well, every decision of the ECHR is pertinent to a specific state, yes, but we are using this as a way of standard, and this is sort of like an opinion on the legislation of a specific state. Can other states use it? Thanks for this question. I believe this is a component of the ECHR case law, and the decisions of the ECHR and in the advisory opinions we're dealing with the legislation of the state. We are dealing with facts, and we are dealing with the international law. Respectively, in the classical sense of the ECHR, to apply these rights, whether or not the resolution part is violated or not, in the advisory, the resolute part includes a legal position, because for the court itself, for the ECHR itself, this is a key case. This is a legal position that fills up its case law, and it is inseparable from others formulated in the decisions, adoptions, the decisions of the Grand Chamber. And given that fact, we should not look at whether or not the specific addressee that referred that this is not compulsory for the implementation, but it's a recommendation as it is. Okay, tell me please, our law says that the ECHR case law is compulsory. Advisory opinions are ECHR case law. Can we consider them as a recommendation if the case law of the ECHR is compulsory for implementation in Ukraine? You mean the courts are using the norm legal opinion? Okay, ECHR case law in different forms, and this is the problem that academia have mentioned as well. We do not have an appropriate concept of the ECHR case law. This is the case law and the European Commission for Human Rights, but what it is exactly, there are legal provisions of the amendments of 3-judge committees. Nevertheless, they're part of the concept, legal concepts of the Grand Chamber, of the chambers. And there are legal positions in the consultative opinions, and they're all together building the case law of the ECHR. Respectively, there are no grounds to remove them from what we consider the source of arguments for the national court. In the positions that are expressed in the consultative opinions, if it's compulsory for the ECHR, then why should we remove that? ECHR justifies this with decisions. Whether or not they justify the decisions with consultative opinions, I did not study that, but the coherent approach and the fact that one legal position is inseparable from others and they have to be coordinated, all of that shows that this can also be the source of law. Another thing is that we're using these positions without manipulation, without taking them out of context, but on a relevant basis. There have to be similar situations. Whether or not Ukraine will have situations with similar facts, we don't know, because we do not know what other advisory opinions, perhaps upon request of the Ukrainian courts. This is a grand chamber at this point. It would be nice to expand the circle of those subjects. We do not know how this is going to be. So I believe, well, my answer would be is that it's a component of the case law, and we need to just detailize the legislative opinion. Thank you very much. Any other opinions, other questions? Okay, I do not see any questions online either. Thanks very much for your presentation. And respectively, we're moving on to the final part of our forum. Given that Petro Rabinovich is with us, and he launched the preconditions for building the conventional system of protection of human rights, your team and you yourselves have launched a discussion in the modern Ukraine on the matters of protection of human rights here in Lviv University on the basis of this forum. So we are extremely grateful to you for that. Respectively, we're waiting for further fruitful cooperation with Lviv University. We will invite you and your colleagues to participate in this event and to build new positions, new discussions, generating new ideas. We're very grateful for that. Thank you. So I have to announce the beginning of the end of our forum. Floor goes to the National School of Judges, one of the key partners of this forum. The discussion took place at a high professional level. We hope that the Council of Europe, in the form of its projects and managers of the projects and the program of Support OSCE for Ukraine, they would not leave the 10 years of this event's hosting with its traditions, dynamics, its permanent members, new members, well, they would not be left without any further support. Irina mentioned co-participation in a completely new context. Given the dynamic interpretation, it may need expansion of its definition. I think we will hereby thank everyone involved for this event on this bright note. We hope that there are certain things that need stability in our calendar and that define, if we're talking about the national identity, that define the annual calendar. And given professional environments, they have certain attachment to the dates. There's Christmas, Easter, the Day of the Judges, the Day of Human Rights Protection, and the Forum in Lviv. So until next time, I wish you all fruitful discussions at the next forum and fair decisions with relevant references to the ECtHR case law, should it be necessary, in your core decisions. And stay safe. We would like to thank our interpreters who were with us throughout these 2 days, carrying the load. They didn't stop us. Only the air alarm has stopped us, but we hope that next year we will not have any air raids anymore, but the forum will exist. Thank you very much.